Boom. Hey folks, how's everyone doing? It's a Sunday, so it'll probably be a quieter day here overall, but yeah, this was actually a surprising hearing. So if you're not sure why you're here, which sometimes happens, today we're going to go over the Baldwin motion to dismiss. So what happened is Alec Baldwin has asked for his case to be thrown out. Specifically, he's alleging issues with the grand jury process. Now, somebody had a comment in chat. It wasn't a super chat, but it was a good comment, so I'm bringing it up. Alex joining the exclusive club of every defendant wanting his case tossed. Kind of. Just about everybody who faces charges, their first question is, how do I get these charges thrown out? And in most cases, they're just isn't an answer that makes them happy, because usually you don't just get to say, hey, this is getting thrown out. You can ask the court to do so on various grounds, but you need to actually have the grounds. You need to actually have the reasons for this. And what's interesting about this one, I'm going to give away the ending. What's interesting about this one is that the judge doesn't rule on it from the bench. At the end of this hearing, what we're going to hear the judge say is, I need a week to decide and to put my ruling in writing, which is not what the prosecution wants to hear. It's not what the prosecution wants to hear at the end of all of this, because normally the result you'd get at the end is just, I've heard from the defense, very nice. Trial date is when it is. So, yes, and there are sort of multiple grounds. We're going to go through everything that they talk about today. We're going to watch this, but it's interesting. It's pretty fascinating that this happens. All right. Now there's some other people who are saying, wait, what about Karen Reed? We're going to go over Karen Reed's Friday hearing on Monday, because there isn't court on Monday. So we're going to go over what happened on Friday. Friday is going to be spicy, or Friday's coverage on Monday is going to be spicy, because, yeah. The other thing I'm going to let you know is I might be a little off, and I'll explain why. So I've been battling insomnia, and Mrs. Runkle had an idea, and I thought it was a good idea. So together we had an idea that is not a great idea in retrospect. And that was, I decided to see if taking my Vyvanse would actually help me get some sleep. And it did the opposite of that. It completely prevented me from getting any sleep. So I have had 3.5 hours of sleep just before this. So we're good to go. Let's rock and roll, because it might be a little extra spicy today. All right. So I want you guys also to let me know if I've got the sound working, because we need that, of course. We're just going to... Nope. I need to be smaller. There we go. All right, let's go. And I see people saying, yes, they know Vyvanse is a stimulant. I know that too. I drink cola to help me sleep. So, yeah. Okay, here's our hearing.
Responses, so replies. So go ahead, let's start.
Thank you, Your Honor. I know the court has carefully read the papers, and we appreciate the long window the court gave today. I'm hoping it won't take that much time.
All right, so you usually say this to the court, and usually what you're following this by is explaining what your case is, because not every judge actually does read all of the materials that you send them. This judge, on the other hand, I do believe will have read everything very carefully. So when he says, I thank the court for reading this, I don't think he's kidding. But you can't always assume that the court has read your materials, because sometimes they don't. This judge will have. She's very careful, at least, especially on the motion stuff.
How we'd like to proceed is break this up into two sections. I'll give.
Also, just a minor criticism. He is running. He's running this off of a laptop, which is why we have nostril cam, that upward view that makes everyone look awful. Lawyers of the world, I am available as a consultant. I will not charge you a whole lot, but I will help you get a better audio-visual setup than nostril cam.
An overview of our view of the grand jury process, and then Mr. Nikas would take the second issue, which would be the waiver, the legal instructions and the arguments and remedies there. So just to start and take a step back about.
Can I interrupt? So when you're arguing things, so there, as you know, there's two types of challenges, and I need you to hone in on which one or both you want the evidence you're arguing should be considered. So the sufficiency, quality or sufficiency of the evidence. And then the second one is the structural challenges.
Yes.
The reason why she's asking this question is because there's different standards for throwing the case out based on which kind of argument it is.
And Mr. Nikas is going to break that down in his sort of subsection.
Okay, very
exactly
good.
Right.
All right. Thank you.
So just taking a step back, Your Honor, and I'm not going to obviously recite the history of the case here, but there's a couple of points that obviously the court, in our judgment, should think about and
Same
consider,
judge,
which
yep.
is the posture we found ourselves in before the grand jury was a case that had been dismissed and brought back. A court can consider, right, how strong a case is, whether it's at the fringes of criminal law or whether it's a case with 15 witnesses, DNA, and video, in sort of assessing these things. So we get brought back on a criminal case, and we were set for a preliminary hearing originally, and it was switched out of that posture into a grand jury, which is, of course, a prosecutor's right in New Mexico. The purported reason was to sort of save the defense something or another, but frankly, we wanted our open court. We wanted the chance to press and cross-examine these witnesses, and the state took the proceeding and brought it into a private chamber. At that point, the notice went out, and it did not have the 48-hour language that, by Miss Morrissey's own statement to the judge, she had never seen a notice without that. And
so the complaint here, this was in their lengthy filings. I did go over the filings before, but the issue that they had here was that normally there's language that basically says you need to get your evidence for the grand jury in 48 hours ahead of time. And Morrissey removed that language. Now, I don't know that this is necessarily their strongest argument, because Morrissey, amongst other things, can argue we removed that because we were going to let you submit things even later than that.
Identical notice served on the co-defendant on the same case didn't have this absence, right?
They're not technically co-defendants. They were both charged, but they're not charged. They're not having a trial together. So calling them co-defendants, I think, is a bit odd. Sort
of surprising. Sort of looking at you saying, what is this? And then further to that, we raised the issue, and there's a fight, a litigation, and the state lost that issue. Then there is the idea of this one-sided voir dire, which seemed a bit unusual. Again, we raised it, they fought it, they litigated, they lost. And again,
So right now he's going over their greatest hits. He's basically trying to establish that they're trying to show a pattern of misconduct on the part of the state, or a pattern of bad behavior. This is usually a good idea. I don't know that he's delivering it in a way that makes me thrilled, but yes.
These things just seem strange to be dug in on, right?
Toss me a DM on
your
Twitter.
Mind kind of goes back, at least mine did, to comments that the judge made. Judge Ellington said, it's the strangest thing. In 30 years, he had never seen the media know when the grand jury was going to convene on a case before the target letter even went to the defendant. Strange. And I start remembering, these comments from the prosecutor about humbling Mr. Baldwin. This is a homicide case to humble another human being. You start thinking, well, what's really going on here? And so ultimately what the judge ordered was that these witnesses, the evidence, be made available to the grand jury.
I'm going to speed him up slightly because
he was not going to deal with logistics. This was the prosecutor's duty, their ethical and prosecutorial duty, to be fair, impartial, to be a guide and a help, not to be an advocate in that moment, to just be the eyes and the ears of the court and of justice. And so, you know, I can tell the court personally, I was concerned, and we sent a letter the day before the proceeding to say, please, we get it. It's a high pressure case. We get it. Everybody, you want the indictment. We get it. There's all these things we brought to the court's attention. The court ruled in our favor. The grand jury is going to be ending soon. Please, we're practically begging the prosecutor. Don't run through the stop sign. Don't be reckless. Don't lose your way. You have to.
We're practically begging the prosecutor. I mean, it's good language. It might be a little overwrought. Like, it might be a little too much, but I don't hate it. I don't hate it.
Have the witnesses and the evidence there, and the grand jury needs to know that.
Slow them back down.
It's a real process. This isn't rubber stamps. So, you know, concerned about that the case was just going to be raised closed, we sent that letter. And I think that's very important, Your Honor. And I think the court should consider that. And from my position, the fix was in. There were no witnesses. There were no witnesses there to testify. There was no evidence binder of the defense exhibits. There was no evidence binder. So even if somebody had wanted to speak to somebody, there was no time, there was no ability. And that is so important because the prosecutor never intended for that.
So here's what the defense is arguing with regards to this. They presented a bunch of... So New Mexico actually has something of... It might actually be unique in terms of how their grand juries are done. It's not something I've seen before, but I've had to do some of the research on this. The defense actually gets a notice as to, you know, about the grand jury, and is allowed to the accused, like, has a right to testify. Baldwin, if he wanted, could have gotten up in front of the grand jury and testified in front of the grand jury. But the other thing is they actually have the ability to send in a letter with, here is the evidence we think the grand jury needs to see. We think that this is exculpatory. Normally, you don't get to tell the prosecution how to run their grand jury proceeding. But in New Mexico, you kind of do. And so the defense identified a whole bunch of witnesses that they wanted the grand jury to have access to. And Carrie Morrissey called none of them to testify, none of them to the stand. And in fact, you know, one of the issues is that they weren't like sitting in the background. They weren't like in the back room ready to go at a moment's notice. In fact, they were just not there at all. So this is going to be a big deal. Is the prosecution is basically saying, listen, you were required to give us our end of the hearing. You were required to give us the ability to counter your evidence by having certain things presented to the grand jury. And you never meant to do that. You just wanted to ensure that there was going to be a prosecution. And that's it. Now, I have said before, I did previous videos talking about Baldwin's case. And one of the things, and in fact, I said this about Hannah too. I said, it's actually kind of concerning that I think they have a good case on the facts, but the prosecution has in some ways risked the charges based on behavior. Now, this is a good question. Somebody says, how much, somebody says, what do you think the odds are of the motion being thrown out? I think it's about 30%. 30% chance that the case just goes away. 30%, on the other hand, is a lot better than what you would normally expect at the end of a motion like this, which is 0%. Now, if Baldwin does have his charges thrown out, this is going to be controversial. And it's going to be annoying to me because I wanted to go to New Mexico to cover this. But there will be a lot of comments about whether it was his money that got that done, whether that was fair to Hannah. So we'll see.
See, just like prosecutors argue in summation, The truth is so compelling. They never intended for the grand jury.
That's
to
what I
ask for
found
witnesses.
too.
They never
Jesse.
wanted the grand jury to ask for exhibits. And so not by deed, not by word, not by spirit, they did not comply with the court's order or the law. And surprise, surprise, the grand jury didn't ask for any of it, right? That's what the prosecutor is going to say. But of course, they were led nowhere. They were led to the closed door of the grand jury room with not sufficient information and explanation. And I'll tell you,
one of the other things I want you to notice as we go through this is just look at the difference in the quality of lawyering we get based on Baldwin versus Hannah. Baldwin's lawyers are much, much better than Hannah had. It's a, you know, and it's not even close, right? It's, these guys have hustle.
the court, and the court's reviewed many grand jury minutes, and I remember many times when I was a prosecutor, but there's a way to do this that's fair. There's a way to say, this is a murder case. I'm just going to give the court an example. There's an alibi witness. This is very, very serious stuff. The defendant,
I was going to say, clarify
says he was
that's
at
an
the movies
example
with his
because it's
mom
not a
at the
murder
time.
case.
He could be completely innocent. There's a movie ticket right here. I'm going to leave it right here on the table. You all should think about looking at it. The defense would like you to look at it. The mom is in the hallway. Okay, we want justice here. You should consider these things. You don't have to do it, but I'm going to leave the movie ticket here and the mom in the hallway. And by all means, we want to get to the right result here. That's not what happened in this case. That's not what happened in this case. And so, you know, and another thing is, again, our letter, the term's ending the next day, you know, that you're going to have to, it's like, listen, understand, we're going to give you plenty of warning so that you can tell your job, so that you can have extra time. If you need more time, that's easy. We will accommodate. These people are waiting here. But there were no people. There were no exhibits because the state was never going to comply. So when we got the transcripts, of course, and we looked deeper at this, the witnesses were diverted, right? You know, it's a very important thing that Ms. Morrissey was preparing for the Gutierrez-Reed trial at the time. She knew exactly what was going on. She knew exactly how to divert the witnesses away from information that helped Mr. Baldwin. She diverted them. And the legal...
So the argument he's making here is basically there are certain points where the grand jury had questions. And so Ms. Morrissey didn't necessarily present the witnesses that the grand jury asked, but instead sort of said, how about you hear this from this particular witness? So this is also going to be an issue. Morrissey is going to argue that she had good reasons, innocent reasons for doing that. But this is a stronger part of their argument.
Instructions, you know, the filing that was made when the issue of the legal instructions was before the prior judge. The state says in there, it's just a little piece in the papers, but it says, we'll insert the language we intend to use. That's what they say in the papers. And they don't tell the judge, I'm going to insert this language that they ended up giving. They don't tell the judge that. And they could have called that judge back at any point and said, we have a question. Just because of all of the concerns in this case and because we want to do the right thing, is it okay if we insert different words? They don't do that. They shut the door to the grand jury room. They got their indictment. And that's why we need this court to step in and check this abuse of power. It's just that simple. You know, I'm going to end and turn it over to Mr. Nikas in a minute on these specific issues. But again, I will sort of end where I began, that this is a case involving an accident at the outskirts, very outskirts of criminal law as we know it. And I don't think there could be much debate about that. There was no check in that grand jury room. The prosecutor was alone to do as they wished, despite every warning and every judicial order otherwise. And, you know, even in front of the court perhaps can see what I believe to be going on here, which is, you know, and Mr. Nikas is going to address this waiver issue, that this response comes in from the state and has no case law in it. It's like a breathless, go get him kind of a response, and that's fine. But you start thinking, you know, are we not losing our way here? Is the high pressure case not starting to sort of take control over good judgment and everything else? And I just think that
this is going to be a hard issue for them, which is that this is going to be a hard issue because this is such a high profile case. The court is not really going to be inclined to throw it out, right? The court is a lot more willing to toss a case if the case is like, you know, a shoplifting or something like that. In this case, he's got the problem that it's, you know, that there's a death, and that's it. You know, that's going to be a big deal. But also, it's got a whole bunch of media coverage. The lawyer's audio is out of sync. This is a recording of a Google Meet. It is out of sync from the through the whole thing.
The court can have no comfort in this indictment, can have no comfort in the way it was procured, cannot possibly believe it was fair and impartial. It should be dismissed. It should be dismissed for Mr. Baldwin and for any other person that comes before a grand jury and falls the victim of an overzealous prosecutor. And that's what we would ask you to do. So I'm now going to turn it over to Mr. Nikas, if there are no direct questions for me to address the specific arguments regarding waiver, the legal instructions,
legally it's irrelevant.
Remedies we saw.
No, I don't have any questions at this time.
Thank you, Your Honor.
Good morning, Your Honor. Good morning.
The thing is this was really just an introduction. He didn't really make a strong argument here. He's just introducing the issues.
I'm getting some feedback.
And you shouldn't be getting feedback, but you know why he's getting feedback? He doesn't have anything in his ears. This is why I'm not getting feedback. I've got earbuds in. Now, to be fair, my earbuds kind of vanish into my hair, but guys, you should have your tech down. Oh my God.
I think it's a little better. Good morning, Your Honor. So I'm going to address 3 issues in a little bit more detail, and I'll try to keep it brief.
Also, I was just struck at how much this guy looks like Agent 47, way more than Bowles did. This guy looks like he's got, you know, a fiber wire in the background. The other thing I'm just going to note here is, like, he's got his trial binders in the background. You can throw up like a green screen, man. You can throw up something. He's got a book about watches in the background. And given that the prosecution keeps giving them grief about how they're from New York City, he's literally got a book in the background that says New York. So, yeah. This is a good point. Ripperjack Media. I've worked with Alex Spiro on a different case. He's the best out there, period. He seems to be doing a great job today. They destroyed the gun, and that's a big issue for the prosecutor. I'm not sure that the destruction of the gun is the hugest issue, but I think that they're doing a great job of making it into an issue. You know, the gun being tested to failure is sort of something that happens, but this is a bit of a, I think that the sort of prosecution issues with regards to the grand jury might be a bigger issue here.
Because we know Your Honor reads all the papers very carefully. So what I'd like to do is highlight
I'd take that money, David.
Key components of 3 issues in the case. The first is waiver. The second is the ground for dismissal that the prosecutors engaged in bad faith, and therefore the court should review the sufficiency of the indictment and evidence that supported it. And the third is the structural problems with the grand jury process, in that it was conducted in violation of the law, and therefore no prejudice is required in order to dismiss. So,
okay, so bad faith is often tough to make out because usually there's some argument as to why the prosecutor did something that is not bad faith. So bad faith is tough. And this is, but they also have a really interesting aspect here that they're saying, like, listen, because of the particular issues here, prejudice is not required. You don't have to show a harm because it's not actually possible to show a harm. And people saying that his suit is excellent. His suit is excellent. I really do love his suit. That said, his suit probably costs more than my car. It's a very nice suit.
I'll break it down into those 3 categories. that we believe justify dismissal independently, each of them, of the indictment. The first, Your Honor, the state has waived its challenges to the motion to dismiss we filed. The state did not cite a single case in its opposition brief. It did not cite a single legal authority in its opposition brief. It did not distinguish any of our legal authorities. And it didn't challenge the majority of our factual statements either. And
So he's basically saying that the government response is so crappy that we should just consider it a non-response at all. That's a bit of shade there. That's a bit of shade.
even when it did purport to challenge
Is that a $700
basis for our
tie?
factual
Jesus.
statements, it mischaracterized our position and argued against
No,
something
this
we
is,
had not, in fact, even asserted.
This is an issue with
For
regards
example,
to the conduct of the
state
grand jury
argues
process.
that Mr. Baldwin asserted the grand jury process was too short, and
Yes, this
therefore
is Alec's
that is
lawyer.
one ground for our dismissal. As you just heard Mr. Spiro explain, our argument was not that the process was too short. It was that if the state was going to conduct the grand jury process consistent with the law, present the evidence that we believe was required to be presented, instruct the grand jury properly as to its roles and responsibilities, then a day and a half would not be enough time to do that. And so that was not a basis for dismissal. That was one of many, many facts that, as we laid out in our brief, points toward the mindset, the motivation of the state in conducting this prosecution, which was directly relevant to bad faith, where the courts have defined bad faith as dishonesty in purpose, belief, or motivation.
Dishonesty in purpose, belief, or motivation. That's always a hard sell, right? That's always a hard sell to accomplish. The court is usually going to be reluctant to find that a prosecutor is, that the prosecutor is acting in bad faith. MLS is saying, I do not practice in a state with a grand jury. Am I wrong to assume that if there was a technical violation, that they couldn't just bring another grand jury? They're asking for it to be tossed. I don't think that they can re-bring it at this stage, but I could be wrong. New Mexico's got weird rules. So, yeah.
And so even where we made arguments about things that were mischaracterized and responded to in a different way, when the state actually did respond. And so ultimately, the state waived the challenge, and we cited a number of cases to demonstrate that. For example, we cited the Delta Automatic Systems case. That was a waiver case. Now, short
Really? It's a
summary,
waiver
Your
case
Honor,
that
just
you're
so you can
citing in the
see
issue of
how
waiver.
on point
Okay.
our cases are versus what the state cited in its supplemental brief. Delta Automatic Systems, plaintiffs filed a brief. They argued their claim was not time barred, it was in the limitations period. The defendant explains, well, no, your case is time barred because actually the limitations period started earlier. Plaintiff doesn't respond to that. What does the court do? The court says, if you don't respond in opposition to an argument, then you've waived it. Dismisses the plaintiff's claim on the merits. There was no discussion of wanting to hear.
Now, you'll note that sounds like he's citing a civil case, right? And the civil case standard may not be applicable. So, yeah. Yeah, and this is a good point. The case already got tossed once because of misconduct of the previous prosecutor. If this case gets tossed again, it's done for good. It's very well possible that'll be the end. So, New Mexico is where it's being tried. So, here's to early retirement for Ian.
The case on the
long
merits.
way
No
from that.
discussion of
I don't know if I'm the
liberally
kind of person who
allowing
can
parties
retire, but
to
thank you
ignore
so much,
responses.
MLS.
Period,
God
full
bless.
stop, dismiss the case on the merits. Same thing happened with respect to an argument in State versus Vaughn. The defendant argued that the court violated his due process rights because he was subject to prosecution for refusing a breathalyzer test, when in fact the first breathalyzer test he took, he agreed to take. He said, you can't prosecute me for refusal when I gave one. Doesn't cite a legal authority to support that argument. Factually, it was true. Doesn't support one. What does the court say? You haven't cited a legal authority.
So this is a
We
criminal
will not
case.
consider an argument that lacks citation to any legal authority. And when you do that, we assume no such authority exists. Period, full stop.
Okay, it's like if you had cases, you would cite them. If you don't cite law on your side, the court should assume that the law is not on their side. Now, sometimes you actually end up arguing issues that are outside the law, right? Where you end up arguing an issue that the law hasn't dealt with. But here, I don't know that that's where they are. I don't think the waiver argument is going to win the day. I don't think that the bad faith argument is likely to win the day. If they win, I think it'll be on their third argument with regards to the structure.
Rejects the argument. No discussion of liberally granting opportunities, etc. We cited the State versus Tafoya case. Same exact thing. Court explains, you, defendant, argued the jury instructions were insufficient, but you didn't cite any legal authority for that. Argument rejected. You don't cite legal authority. You don't oppose legal authority that's cited to you. You've waived it. And what does the state say? The state does not distinguish our cases. It doesn't challenge those principles. Instead, if Your Honor even considers the state's supplemental reply, which we don't think you should, because the waiver cases do not allow that. But even if you did, Your Honor, and you looked at the cases the state cites, none of those cases are about waiver. They're about default judgments, which we know is a very different scenario from waiver. For example, in the Gangler versus Phelps case that the state cites, the plaintiff sued two defendants. The parties agreed that
I'm just going to note here, this guy has also clearly done his work on prepping this. People who are lazy, and lots of lawyers are lazy, often don't read the cases that are cited by the opposing side, right? The other side cited some case law. He's clearly read the case law that the other side has cited, and he's prepared to address it. That is, and this is important. This is critical. I have won cases repeatedly where you just are able to say, like, this case that they were relying on is not correct. Now, somebody says citing case history from memory. I am sure that he prepped this. I'm sure that this isn't just somebody mentioned the case and he's like, just joined. What are we watching? Recap, please. We are watching the motion to dismiss Alec Baldwin's charges in the death of Halayna Hutchins.
Defendant's time to answer would be extended. When they entered the order, however, it only applied to one of the defendants. It was an accident. One of the defendants, therefore, didn't respond on time. The plaintiff got a default judgment. What do we think happened? Of course, the court said, we vacate default judgments liberally. And everyone thought this was supposed to apply to both. And so we're not going to hold you responsible for not responding on time. Springer versus Herrera, same exact thing. Default judgment entered, and the court says we liberally vacate default judgments. Nothing about waiver. SunWest Bank versus Rodriguez, another case the court cites, or the state cites to the court. This is an interesting one, Your Honor. There for a couple of reasons. There, the plaintiff sued two defendants.
He's going through the opposing case law, dismantling each case.
Because they defaulted on a loan. The wife or the ex-wife comes into the court after a default judgment was entered and says, I didn't know this wouldn't be handled.
He's got his screen.
My ex-husband has all the information about this. I thought he was going to answer the complaint. And therefore, this is excusable neglect. The court says, fine. We think that is excusable neglect, but ultimately we don't find your defense on the merits persuasive. And therefore, we're keeping the default judgment intact. And why is this interesting, Your Honor? Because when you look at these default judgment cases, even though they don't apply here, even though the waiver cases are the controlling cases, and we ask ourselves, even if we applied that standard, excusable neglect, would the state be able to meet it if that were the standard? Is the state's knowing and intentional failure to respond to any of our legal arguments, any of our cases, its failure to cite any cases of its own, excusable neglect? How about the state's failure to address any of our factual statements? Is that excusable neglect?
So this is an argument that I would make it. It's you definitely want to make this kind of argument if it's on the table, but you also always have to recognize that the court is going to be reluctant, and especially I feel like the court might be reluctant to specifically find neglect or bad faith in a case of this level of media attention. So
no, it's not. This is not a case where the state failed to answer at all and said, oops, we missed a deadline by accident. Can we please file our brief now? Where in those circumstances, the court would look at law office failure and technical issues. That's not this case. This is a case where the state did respond, and they responded on time. And they made the response they made deliberately, knowingly, with a calculated strategy to disparage Mr. Baldwin, to disparage me personally.
Calculated strategy is, but he's presenting this very well. I think that this is very, very well argued, and I'm impressed so far.
Rather than deal with this case on the merits, knowing full well the risks of taking that approach, this would not be excusable neglect, even if we did have to prove it, which we don't. And the state also cites this People versus Davenport case. That was a Colorado case about civil forfeiture, where the defendant didn't show up in response to a civil forfeiture claim, got a default judgment and said against him and said, but that should be vacated. And when asked why, he said, because the statute says I can either file a response or appear in person. I filed a response. The court says, yeah, that's right. You did. You complied with the statute by filing the response. You forgot to pay the fee, but you can do that later under Colorado law. Therefore, the default judgment shouldn't have been entered in the first place. Those are the state's cases, Your Honor. None of them on point at all. The only one that has some language that, even if it were relevant, it's not, would actually support the entry of dismissal because of the state's waiver. And so the state waived these challenges. It was the state's decision.
Now, I got to say, I think this is off Law and Crimes feed. Let me just move myself. Yes, Law and Crimes feed. Their chat was really critical of this guy. They were saying, oh, he keeps talking. He's got so many words. And I'm like, I'm listening to the words. I think he's doing a great job. He's going through each case. He's attacking it. And I'm following him. Like, this is...
to present its opposition as it did, the state's decision not to cite a legal case, the state's decision to do all of these things. And the state said, well, that wouldn't be fair. It wouldn't be fair. It wouldn't be fair to give them this opportunity, to have them take the approach they wanted, and then give them a redo. Let's talk about fairness for just a moment, Your Honor. Let's talk about what the courts say about fairness in the context of a grand jury proceeding. Herrera said we need to protect the target's fundamental fairness. Strict adherence to the rules is required. Ulibarri said that prosecutors must conduct themselves, as Mr. Spiro said, in a fair and impartial manner. Ulibarri said that it's the target's right to a fair and lawful process that should be rigorously protected. That's what fairness is about in these circumstances. It's fairness to the target. And
the target is Baldwin. Now, the thing is that in the criminal context, trial fairness almost always is a thing that applies to the defense as opposed to the prosecution. The prosecution has far less trial fairness rights than the defense does. So I think that's a very sort of critical element there. So Eric, check out his response. If you think his argument is weak, the issue is the judge didn't, because the judge doesn't throw it out immediately, which is what you normally expect to see on all of these things. I don't think he's going to win, but I think he's doing a good job with what he has. I I think he's doing an excellent job of making a small issue into a larger issue. And sometimes that's what the job is about.
The only unfair outcome here on waiver would be not to apply waiver cases and not to dismiss this indictment on the basis of those controlling cases when the state brought this circumstance on itself by choosing the response it made. That's ground number one, Your Honor, on which we believe the court should dismiss the indictment. Ground number 2 and 3, as I mentioned, bad faith and judicial review of the evidence, and then the structural defects in the process. I'm going to start with the structural defects in the process, the violation of the grand jury process. Under New Mexico law, that is a basis for dismissal without proving prejudice. Once again, the state doesn't cite any cases about this ground for dismissal.
Now, this is where things are going to get confusing because there's things of dismissal with prejudice versus dismissal without prejudice, which basically means case thrown out permanently versus case thrown out but can be rebrought. But that's not what he's talking about. When he says prejudice here, he means prejudice to Mr. Baldwin. He doesn't have to show that Mr. Baldwin actually was hurt, just that the structure was bad, right? So, and the reason why this is important is that it can often be very difficult to show an injury, a harm in these kinds of issues. So,
in the state's supplemental reply, they say we've misrepresented the fact that bad faith is not required. It's very clear, Your Honor, we put it in our brief that bad faith is required on the third ground I'll talk about, but it's not required on this second ground. The courts have made that clear in New Mexico. Herrera said, for example, when we're talking about a violation of the grand jury process, a different standard applies to the target's claim, different standard from bad faith. That's quoting directly from the Herrera case. And the reason is that the grand jury process is one where the prosecutor has the control. There's no direct supervision of the judge, as Herrera noted. The prosecutor has the control of the room, the control of the witnesses, and ultimately has to rigorously follow the grand jury process to ensure that the grand jury has all the evidence before it so it can comply with its obligation to receive and evaluate all of the exculpatory evidence, all of the evidence that may make an indictment less justified.
Now, this is, again, really interesting because in most places, this isn't how grand juries work. The old line is that you can get a grand jury to indict a ham sandwich. Now, ham might be the wrong particular thing because typically in a lot of states where you see the grand jury not indicting, it's police officers, because grand juries are also a way sometimes for prosecutors to make an indictment go away if they think it's inconvenient. But here, in New Mexico, the rules are different. The rules allow for this enhanced due process element. Like the grand jury process in New Mexico appears to be a process that really contemplates some due process. And so, yeah. Now, I will also just say, if Baldwin wins on this issue, it's going to be unsatisfying to a lot of people. But, and so we're going to see a lot of continued argument in the sort of the media, the press, as to whether or not that was fair. A lot of people don't think Baldwin should have been charged at all. I'm not in that camp. But a lot of people also are concerned about the influence of money in the process. So it'll be interesting to see what the responses are. I'm really, really looking forward to reading the judge's response, and I will, the instant that comes out, we'll be doing a review of that.
And so in the Herrera case, I want to start there, Your Honor, because in the Herrera case, there were 2 grounds for dismissal.
Somebody says he's mispronouncing Herrera, and I'm not hearing it.
The prosecutor asked the witness a question and the prosecutor didn't let that witness answer it. And the court said, ultimately, if the prosecutor had questions about whether the grand jury should hear that information, should have its questions answered by that witness, then the prosecutor should have gone to the judge. And the second was, and we see a lot of that here, Your Honor, as we've explained in our briefs. The second is that the prosecutor read proper.
Now, I'm not sure that it's directly on point, this issue of the prosecutor not asking the question. So I don't think it's directly on point. I think it is a good, Herrera. Okay. Fair. I am familiar with Brandon Herrera, so fair. I don't know that this case is directly like 100% on point, but I certainly think it's persuasive to get us there.
JI instructions to the grand jury, but then commented on one of them in a way that was consistent with the instruction, but sort of expounded upon it a bit. And the court said, no, we have to comply rigorously. We have to read those instructions exactly as they are, word for word. We cannot manipulate, we cannot change, we cannot modify. It is critical that the instructions are exactly what they need to be. And they weren't, and that failure also provided a separate ground for dismissal. And so let's start here, Your Honor, with the three reasons we give on this ground, independent again, for dismissing the indictment on the basis that it violated the grand jury process. The first is that the jury instruction was inaccurate. The first element of the jury instruction that the state read was that probable cause exists if the grand jury finds that the target discharged a firearm during the production of the movie without first verifying the firearm contained no live ammunition, and while the firearm was pointed in the direction of another. The state then had a witness testify that Baldwin had an obligation to verify the firearm contained no live ammunition. There are two pieces of this, Your Honor. The most troubling to us, the instruction.
So, this is kind of the crux of the dispute, which is that, does Baldwin have an independent obligation to check the gun versus does Hannah catch all of the blame, right? And I know a lot of people in the film industry are specifically saying, no, this is the armorer's job. It should be 0% the responsibility of the actor. The problem with that is that the case law doesn't actually separate out films as a different category of things. And so where you end up with the issue that the prosecution is arguing is it doesn't matter if you are on a film set, you are a human being. And so they point to things like the Screen Actors Guild guidelines that note things like, A, don't point a firearm at somebody, but also things like you have a safety rule and that the law takes precedent. Like the law has the priority over whatever rules we have. So this is going to be a huge issue at the trial as to how much responsibility an actor can have here. I can tell you that in Canada, this is a very simple legal question, which is that Mr. Niklas's argument, I keep saying Niklas because I know a Niklas. Mr. Niklas's argument in Canada would be a non-starter. The case law is very clear that you always have a responsibility when you're handling firearms or explosives or things like that, that you cannot fully displace onto another person, that you have an obligation to be familiar and knowledgeable enough not to be dangerous. But Canada isn't New Mexico, but the prosecution is certainly arguing that the case law says, hey, you point a gun that you're not certain is unloaded. You just took somebody else's word for it without actually seeing that. That would be, you know, that would be considered manslaughter for anyone else. The fact that you're an actor doesn't change that. You had to, you know, you had to see that. I'm kind of inclined to agree with that. I don't know that that is the way the jury will think about it when they're dealing with it. I think Baldwin's got a good chance to walk, even though I don't think he should. But he has a good chance to walk, in my view, just because of that's how a jury's going to look at it. I think, ideally, this should result in a bit of a shakeup in standards, in the sense of whoever's taking the gun should be being careful to be certain that it's unloaded and to be certain that it's safe. And that might mean that the talent has to actually learn some things about guns. That if you want to be on a movie where you're taking guns and pointing them at other people, that you need to learn some things there, right? You need to learn how to do this safely and not entirely rely on someone else. So, yeah.
Instruction is not correct. Judge Ellington heard argument on what this instruction should say, and we put our position forward.
In Canada, firearms
should
also go into the category of
subjective
like
knowledge,
that kind of
which we think
hazardous
is
thing.
The law in New Mexico, and the state said this is not about whether Mr. Baldwin should have verified whether the firearm contained live ammunition. There are other grounds completely distinct from that serve as the basis for this indictment. And Judge Ellington accepted that argument, that representation, that that's not what this case was going to be about. Shocked we were when we see the grand jury instruction inserting this exact language that the state had just argued was not going to be the basis for its case. Again, the grand jury judge was there for guidance. If the prosecutor had concerns about whether this language could be added in, that's what the judge was there for. That's what Herrera said the prosecutor should have done when deciding to cut off the witness. So that's troubling, Your Honor. What's even more troubling,
so he's saying go to the judge,
is that the state called Brian Carpenter to testify in the grand jury. And Brian Carpenter testified that it was Mr. Baldwin's responsibility. Brian
Carpenter was, you guys in the chat were a fan of Mr. Carpenter. He was, I thought he was a good witness. He was the guy who was talking about, he's the armor, right? I thought he was a good witness. Of course, they're not going to say that he is, but they're going to say that there was too much reliance put on this guy and that other witnesses should have been asked some of the questions that were kind of steered over to Mr. Carpenter. So, yeah, I mean, as an expert, he was much better than the defense expert in the Hannah Gutierrez Reed trial, who pointed a gun. Well, it was ultimately determined to be a replica, but pointed a gun-like object at the judge. That didn't sell well.
To check the firearm, Mr. Baldwin's responsibility to verify the ammunition, and the gun was not live ammunition. It was instead a dummy or a blank, and that was definitive. They also had Detective Hancock say that the actor had to do the safety checks. 2 weeks later, Your Honor heard testimony in the Gutierrez Reed trial that was exactly the opposite of that.
This is true, and I pointed this out in in Hannah's trial, which is that the prosecution seems to be arguing two different issues sometimes. So at Hannah's trial, it's like the armor is the sole line of defense, but at Baldwin's trial, it's no, the actor also has a responsibility. That is interesting, although that happens when you got multiple cases.
We've quoted that testimony in the brief, Your Honor. Mr. Carpenter said actors sometimes view the safety checks, but that's for a warm and fuzzy feeling, and that's rare. He said,
Now the question is this what the law actually is this what the law actually says, right? Is this how the law says this works, or not? So yeah.
sometimes actors say, nah, his words, nah, I don't want to check the gun. And
that's a good thing to quote. I think he's doing a great job. Like, I think he's got an uphill battle on his argument, but I think he's doing a great job of making it.
it's okay, as long as you've checked it with the other sources, the other people who are responsible for checking it, not the actor. It's the armor's responsibility for verifying whether the gun has live ammunition in it or not. And you heard Ms. Morrissey in closing argument say the armor's the autonomous decision maker.
Yep.
The actor is going to manipulate the gun. Of course he is. That's foreseeable.
That was, in fact, part of her argument. And I absolutely think they're right to hammer him on that. I do think that they're right to bring that point in. An armorer who says they don't rely on actors checking their firearms is not doing their jobs. They should make sure that the actors follow their rules or no access to firearms. It's tough, right? Because the problem is a lot of actors are very, very talented idiots. And I don't mean that as, well, I mean, it's obviously kind of a dig, but I mean, it's a different skill set, right? Keanu Reeves, great with a gun. Like, you can see him going to town with the gun, right? But a lot of actors don't like guns, aren't familiar with guns, don't know what guns are about, really. And so they're relying on someone else. The question is this the law? Is this what the law allows? Because it's definitely how Hollywood works. So, and the thing is this case, the decision in this case could have tremendous impact on the film industry, and especially not just on the film industry, but also on like the armorers within the film industry, because of, like, will actors be willing to handle a gun, like a real gun, on a film set? You know, and will armorers want it if the case law says, listen, you can't, you can't necessarily be trusted on that. And yeah, Keanu and Halle Berry went to Terran Firearms. They learned a lot. I would love to book something with Terran Tactical. I'm terrified about what that would cost to book like that kind of training program. But if I ever win the lottery, I'm going to give them a call and be like, hey, I want to learn to shoot.
Your Honor, we do not think, as an officer of the court, a lawyer can elicit testimony from a witness on these grounds saying X, and then 2 weeks later procure a guilty verdict in a related case by having that witness testify not X. We do not think,
I actually think that this is especially true when you're talking about the prosecutor, because the prosecutor has a heightened burden of fairness and sort of honorable conduct.
Officer of the court, a lawyer should be able to argue one theory to the grand jury and then in a related case turn around and argue an opposite theory to obtain a guilty verdict. Just as an officer.
Yes, the four rules of firearm safety apply to everybody.
But to push it even further into the context of the grand jury process, all these cases, Herrera, the grand jury statutes, they all say the prosecutor is there, and as Mr. Spiro explained, there not to be the grand jury, but to aid the grand jury, to ensure a fair and impartial process, to ensure the grand jury hears the evidence that's contradictory. Lampman said, for example, if you put a prosecutorial witness up, a state witness, and that witness has information that's contradicted by another, you have to call the other. Limp.
This is, again, because the prosecution has a higher code of, higher standards. And keep in mind, the vast majority of criminal defendants do not have access to Agent 47 here, who's trying to fiber wire the prosecution's case. The vast majority of defendants have very few resources. And so we do expect the prosecution to treat things with some degree of fairness. In Canada, we say the honor of the crown is at stake. That's sort of the argument he's making here.
Been dismissed on those grounds. That didn't happen here, Your Honor. Exactly the worst scenario happened here. The same expert says X. 2 weeks later, the state has that expert say not X. That is not fair and impartial, Your Honor. That is not the presentation of contradictory evidence. It's exactly the opposite of that. That's number one, Your Honor. Related to this instruction, the premise of it, the history in front of Judge Ellington, and Your Honor has those orders and has that briefing. Number two, again, under the violation of the structural rules, the process, the state failed to advise the grand jury of its proper authority and role, and failed to correct the grand jury's inaccurate view or misunderstanding of its authority in these circumstances. The rules are simple. Grand jury is required to obtain exculpatory evidence. The word under 31.6.11b.
I'm just going to note here, Mr. Puff has some film experience, and so, caution. But the other sort of note here, I keep meaning to reach out and talk about a particular case that he's got some experience on. But sometimes they do point guns at each other. They cheat angles as much as they can, but sometimes guns are pointed at other actors, right? It's just a matter that it should be done in a fashion that is super, super safe. He's not technically arguing via Zoom. He's arguing via Google Meet, which is like Zoom, but worse.
Shall.
Sorry, YouTube.
Obtain, not may.
I hate
or might.
Google Meet.
And the prosecutor has an obligation to facilitate the grand jury's inquiry into that evidence. And again, facilitate is the word the courts use to describe this obligation, even above and beyond what the prosecutor decides to present. The prosecutor is there to be the aid to the grand jury, to ensure that the grand jury understands its role, its responsibilities. The state did exactly the opposite again. The state told the grand jury who the witnesses will be, not might be, not maybe, not the witnesses that the state intends to call, who the witnesses will be.
That
And
seems
then
like
the
a
state
language quibble to
reinforced
me.
This message by saying that the grand jury could consider the alert letter or just begin hearing witness testimony without explaining the third option. Consider the alert letter, hear the state's witnesses, and, as Mr. Spiro explained, call the alibi witness out in the hallway and look at the movie ticket. That third option
They're going
was
to
never
rely on that
explained,
metaphor.
number one. And number two, it's clear the grand jury had no idea that was an option at all. Because when the grand jury was asked, how do you want to proceed? They said, well, I guess if that's all our questions about this letter, and the question they asked, Your Honor, was about a typo. They said, I guess we'll begin hearing witnesses. In other words, the witnesses the state told them definitively they were going to hear from. And so the whole exchange in the grand jury transcript demonstrates that the grand jury did not understand the purpose of the alert letter, its obligations and responsibilities, and the state didn't correct them. The state never explained Baldwin's witnesses were available to testify. In fact, they weren't. Mom wasn't in the hallway. Even though Judge Ellington told the state, you need to arrange for the scheduling to make them available.
This, I think, is a big issue for the prosecution's case, for their argument, because, it's one thing to say, listen, the grand jury had the option to talk to these witnesses, but none of the witnesses were actually there, right? None of the witnesses were actually present. And so if they did want to talk to one, it would have been like, well, we got to wait for several hours to get that person in. Do you think the grand jury's going to want to wait, or do you think they're going to want to actually hear from that witness right away? If they hear, hey, it's going to be a few, and if you're saying that these witnesses are available, if I was the prosecution, I would have wanted available to mean they are literally sitting in a room in the back and I can just, I can have them here in a second. Just even if for nothing else to deflect this criticism, right? Even if this was, even if that was all it was, right? So, yeah.
The state didn't even call them, didn't contact them. They never intended to call these witnesses. We gave multiple.
This is the other thing, is having the witnesses available would attack this argument of bad faith, right? You'd say, I totally meant for them to be there. Why would I pay for all these witnesses to be present? And, so forth. So, yeah.
Examples, Your Honor, of briefing in our briefing where the
I don't
grand
think they
jurors
had
were
her on the
asking for
list. I might be
information
wrong.
that would have been answered by the SAG statement, by Dave Halls, by Sarah Zachary, the industry safety guidelines, Joel Souza, or any number of other sources. Instead, when the grand jury asked those questions, the state cut them off, exactly the kind of behavior in Herrera that justified the dismissal on this ground, presented testimony from a different witness, and oftentimes testimony that contradicted what a different witness would have said. Carpenter's the best example. Or Adigio. Adigio suing Mr. Baldwin, seeking money damages. And Ms. Morrissey put some footage on a screen for Adigio to explain. And as we've all seen, intervening cause is a material issue here. Judge Ellington required the
intervening cause is basically, did somebody else cause the issue? Did somebody, intervening cause might be like, what's a good example here? Let's say I shoot at somebody and I hit them in the leg and then they die the next day. You might be saying, wow, Ruggles going to jail for murder. The problem is that if in between that time frame, the guy is attacked by somebody else with a fire axe who chops him into pieces no bigger than an orange, then we've got an intervening cause, right? It might not be my shooting him, might be illegal for other reasons, but it may not be the cause of the death. The intervening cause is axe murderer. Intervening cause can especially be a big deal when you're talking about sort of negligence issues, as this one is, because often when there's one negligence, there's lots of negligence. So, yeah.
Instruction to be read if there was evidence to support it. The state read it. And so Mr. Adigio is testifying about the footage that the state had put on the screen. And he says, well, there are a number of things that I'm concerned about here. First of all, as soon as Mr. Baldwin emptied the firearm and we had to reload it, Dave Hall should have called cut to give everybody the moment to safely reset. It appears as though, he continues, the armor is putting spent ammo in the same fanny pack or pouch as live ammo as she's pulling live ammo out of it. You kind of went past this for a moment, Adigio says to Ms. Morrissey. Dave Halls, the first AD who is in blue jeans and a black shirt, is not. Ms. Morrissey cuts him off. He's explaining intervening cause. I couldn't have dreamed of better testimony to start to explain intervening cause. Ms. Morrissey cuts him off in the middle of it. And after she had already taken something off the screen that he was trying to explain, and she says to him, and keep in mind, we're here for Mr. Baldwin. Point your narrative. What is Mr. Baldwin doing in this scene?
And so this is big for the defense because, of course, the defense wants to to say that it's Hannah's fault. Now, I think this is really interesting because we're also hearing that they have a joint defense agreement between Hannah and Baldwin, and yet they're pointing the finger at each other. It's very weird.
We watched, and anything that happened after, when the camera turns off, because we're not there, that's concerning you. That's exactly the kind of conduct, cutting off a witness, withholding evidence a witness is about to give. That ground alone in Herrera was a basis for dismissal, independent of anything else, that one thing. And that's because the whole point of the grand jury process, as Judge Ellington explained it in some of his orders, to give the grand jury more, not less. This is exactly giving the grand jury less.
I feel like that's Bowles, not
intervening
Nikas.
cause. And then, as we explain in our brief, Your Honor, there are examples of where the grand jury...
Joint defense agreement here is that they are working together to defend their clients. The reason why this comes up is because it means that their communications between each other may also be privileged and protected. Normally where you might see this is something like two people are in a car together and the vehicle turns out to be full of drugs or something. Those two people might have a common argument for their defense.
Misunderstood evidence and said, Mr. Baldwin refused to check the gun. And then he got the gun. How would he check it? Would he shake the bullets? Would he put them in his hand? A question that has no premise in the evidence and is not accurate. Instead of correcting that misunderstanding, instead of having a witness who could explain Mr. Carpenter, as he did in the Gutierrez trial, saying the actor has no responsibility, she cuts it off. She calls Mr. Carpenter, who testifies exactly the opposite of what he testified under oath in front of Your Honor in the Gutierrez-Reed trial. Mr. Baldwin was responsible for checking the firearm.
Right.
And verifying whether it had bullets. Exactly the opposite. These are things that Herrera dismissed the indictment for. And
so they're relying very
look
heavily
at the
on this
grand jury
case,
record,
which I don't think is
that first point I made about the
100%
grand jury's
point.
understanding of its role and responsibility. There's literally nothing in the grand jury record, nothing in the transcript to show that the grand jury was informed of its obligations and responsibilities. The state says, well, that's the court's responsibility. Judge Ellington should have done that. Well, there's nothing in the record to show what they learned, what they received, and how they were told about their responsibilities. The state didn't do it, and the state didn't correct it when it was clear they didn't understand. And the Ulibarri case, Your Honor, dismissed for exactly this kind of reason. In Ulibarri, the state argued that the grand jury was given a grand jury instruction manual, apparently from the description of a big pile of information that had all the things the grand jury could ever want to know about: its responsibilities, its roles, all the different kinds of crimes that exist, the elements of the crimes, everything you'd want to do to instruct a grand jury about how to be a proper grand jury was in that manual. But the state, when it came time to read the jury instructions in the Ulibarri case, just referred the grand jury to the manual and showed them how to use it and said, go there, and that's where you'll find the instructions. The court dismissed the indictment on this ground. Didn't have to prove prejudice, didn't have to prove materiality, because that violated the process. Why did it violate the process? Because the court explained in Ulibarri, it's the prosecutor's obligation to act in a fair and impartial manner. It's there to ensure that the grand jury received all the information it was supposed to receive. And the grand jury was supposed to be aided by the prosecutor in doing that. And there was nothing on the record, even though the prosecutor said that they gave the grand jury this manual, and even though the grand jury was supposedly told how to use it, there was nothing in the grand jury transcript that gives us or gave that court confidence that the grand jury had been properly instructed. Nothing in the transcript. And the court said that alone requires dismissal. If you can't, in the four corners of the transcript, find those instructions and have confidence in this indictment that the grand jury knew its role and responsibilities, then that's the end. Dismissal. No materiality required, no proof of prejudice, no proof of bad faith.
Basically, he's saying you follow the rules or the case is gone. And they're noting they're not following the rules. Luke, I thought about like bringing out Herrera to do a discussion. I don't think that the issue is exactly the same. I think it's close. So I would certainly try to distinguish it, but I mean, I'm not saying it's a ridiculous citation here. It's just that the distinction between how the sort of, it's a different kind of deflection, if that makes sense.
In the State versus Hill case, we talk about grand jury secrecy. We read in the New York Times when the grand jury date would appear. The New York Times reported that Ms. Morrissey had conducted an interview, explained that the grand jury would take place on
Not
November
exactly
16th,
either.
And there were a lot of other
We'll get
comments
there.
about the firearm and the trigger, things that the prosecutorial rules of ethics don't allow prosecutors to say. Focusing particularly on the grand jury date, but also the rest of it, but on the date. If we look at State versus Hill, State versus Hill had a special prosecutor involved, and that special prosecutor had not been properly appointed. Therefore, when the special prosecutor was in the room of the grand jury presentation, there was an unauthorized person in the room. The court said, end of story, indictment dismissed. Why? Because the grand jury rules need to be enforced rigorously.
Now that's
Secrecy
stricter than I would have
is
expected.
a vital requisite of grand jury procedure. Quote unquote, State versus Hill. The fact that there was an unauthorized person in that room meant that the secrecy rule had been violated. Highly, highly technical.
Basically, the argument he's making here is that even though you might say these rules are, technicalities, he just used the word technical, that doesn't mean that, that these things are insignificant. The court has been willing in the past to throw out things on these kinds of technicalities. And so essentially the argument is they were willing to toss things on a much less serious violation. So this is a more serious violation. They should throw it out here too.
No proof of materiality, no proof of prejudice. Didn't matter. We safeguard the system. Secrecy is a vital requisite. The state disclosed the grand.
That also seems weird to me that like secrecy is a thing in them, because I'm always like, shouldn't we have open courts? But it's a different sort of rule there.
Jury date to the New York Times in an interview. We've cited the article. That breached the secrecy rules. So did a number of other comments. You have all the briefing in front of you related to that.
I don't know.
That alone
is the date a violation?
As Judge Ellington said, could cause.
I want to see how the judge
prejudice,
responds
which we
to
don't
this.
have to prove anyway. But Judge Ellington said, I am deeply troubled. The world knows this grand jury date. I don't want to read the New York Times tomorrow about anything that's happened here. Clearly, he had read the New York Times before and saw that interview. Because there are members of the grand jury coming to me, at least one.
He
coming to
turned
the
it
clerk
down.
And saying, I want to sit on the Alec Baldwin grand jury. That's entirely unacceptable, highly prejudicial.
I mean, this, I think, happens with any big trial. But the point he's making here is that they knew it was the critical day, right? That it was the critical, and so how do they know it's that date if secrecy has been maintained? So that's, but I mean, like, people want to be on famous juries sometimes. They shouldn't, because being on a jury often sucks, but they often do.
That's exactly what State versus Hill was getting at. You violate the secrecy rule, which that interview did by disclosing that date to the New York Times. Yep. That's the end. Rigorously and strictly enforce the rules. And this whole process, Your Honor, violated the rules from start to finish. The secrecy rules, the court ordered that witnesses be available. They weren't made available. They were not called. They were not scheduled.
If the other side breaches an order of the court, you always are going to want to hammer that as hard as you possibly can.
The state went on multiple media shows and made statements that violated the grand jury secrecy rules. in violation of the ethical rules as well, governing the statements that prosecutors can make, which Judge Ellington expressly called out, as I mentioned. And we actually learned just this week, Your Honor, that the state paid Brian Carpenter to go on multiple TV shows, including the Sean Hannity show, to disparage Mr. Baldwin, make comments about his ultimate guilt, saying he pulled the trigger, had a duty of care, saying the prosecution was doing an excellent job, not disclosing he was a paid expert, being paid to go on a TV show to disparage Baldwin by the state. And so that's the second ground.
Now that's interesting. Like, it's fine to have a paid expert, but how is it part of his role as an expert to do media interviews? That I think is interesting. And yes, I'll be covering the latest Corey Richins thing as soon as I can find time.
Honor for dismissal. No prejudice required. The third ground is that the prosecution acted in bad faith, which allows the court to review sufficiency, and the judicial review of the indictment and the evidence demonstrates that it should be dismissed. Now, number one, the state, again, cited no cases on this other than saying bad faith is required. On this standard, we agree with that. That's not the standard for the second ground. It is for this one. If you look at bad faith, Your Honor, bad faith is defined very broadly. It's dishonesty of purpose, belief, or motive. And we've cited numerous examples. I won't belabor the court today. It's all in our briefing, pages 36 to 38, for example, of our opening brief. Several examples of dishonest belief, purpose, or motive. Things like granting the 48-hour deadline to Gutierrez Reed, and on the same day saying to Alec Baldwin, you're not going to get that 48-hour deadline, even though we've never seen this done before. Those are the sorts of things that in the aggregate and individually are sufficient to show a motive, a purpose, a belief that we believe opens the indictment to judicial review.
Now that's always going to be a bit of a tough sell, but I mean, props to him for swinging for the fences.
So does Carpenter's testimony. Having a witness testify one thing in one trial, and then the opposite in one presentation, and the opposite in another, shows dishonesty in purpose, belief, or motivation.
I would also say it's going to make it very difficult when Carpenter gets up to testify in the Baldwin proceeding, right? When he gets up to testify, like if they call him as an expert in Baldwin's case, all of this will be fantastic fodder for cross-examination. You never get this on an expert. This was from a live video hearing. So this was done live. He didn't record his submissions.
Your Honor has all that. I won't belabor it. When you look at the evidence and do a judicial review of sufficiency, it's important to look at a few different examples. Again, I won't belabor the point. It's all in our brief. But I want to highlight two things.
You've belabored not belaboring it.
The state called Detective Hancock. The state called Detective Hancock, and at the same time, she was on Mr. Baldwin's list of witnesses that we submitted to Judge Ellington and believe should be called to testify in front of the grand jury. Judge Ellington said, if you call any of these witnesses to the state, you're not required to ask word by word the questions that Mr. Baldwin put in his attachment to the alert letter, but you are required to elicit the information from those witnesses that Mr. Baldwin is intending to elicit so the grand jury can hear it. When you look at Detective Hancock's testimony, Your Honor, what you'll see is that Detective Hancock gave very tight testimony under very tight questioning from the state. She said Mr. Baldwin was required to do the safety checks of the gun, even though Detective Hancock had been specifically told by certain witnesses that he wasn't required to do that. She testified that the investigation was perfectly
This is again
proper,
going toward bad faith,
was
right?
Secured, etc., even though there was specific evidence in the state's files from Chilling, for example, that it wasn't.
And we know that their crime scene was not properly secured. We saw that in we saw that in the Hannah Gutierrez Reed trial. The question is, was that like for Hannah's trial, that wasn't sufficiently relevant? Like there wasn't a big deal about that, but yeah.
She was asked a number of questions,
Yes.
very tightrope, that did not elicit the information that Mr. Baldwin argued should be elicited, and Judge Ellington approved that. So if you look at that testimony alone, Your Honor, you will see
yes, Hancock is the lip lady.
the requirements of Judge Ellington's order and New Mexico law. The state put Carpenter on the stand. You've heard the contrast as I've described it. The case law is very clear, Your Honor, that when you put a witness on the stand, a state witness, and that witness, a law enforcement witness, a law enforcement expert, gives testimony, you're required to put on testimony that contradicts it. The state doesn't do that.
So a lot of what they wanted to argue here was, again, towards this standard of what should an actor be expected to do? Like, is there an expectation that Baldwin will specifically check? That's going to be sort of the issue there.
We've put all this evidence in our brief, Your Honor. Your Honor has the grand jury alert letter with that, so I won't go through it all. But the bottom line is that the list of evidence that the state had in its possession did not elicit and should have elicited is significant. Its own gun expert testified the FBI broke the gun, no signs of modification. Admits in the Gutierrez Reed trial that the firearm shows evidence of rough tool marks on the hammer. We could go on and on, Your Honor. The point is there's significant evidence that was not presented to this grand jury that should have been elicited from Detective Hancock, that should have been elicited to Carpenter, that contradicted the evidence the state had presented at the Gutierrez Reed trial, that upon review in the aggregate, we believe is more than adequate to show this indictment should be dismissed when you conduct a review of sufficiency.
So this is, again, the argument. The suggestion here really is that is that this gun was modified to have a lighter trigger pull. That is going to be an interesting argument, because I'm just like, ooh, that's exciting.
And so those are the three grounds, Your Honor. I'll stop and ask if you have any questions, but otherwise our briefs detail this extensively, so I'll rest there.
All right.
All right. So, he's saying, okay, over to you, Judge. Do you have any questions? And at this point, you definitely kind of want questions. You want to know that, right? So,
Thank you. I'm going to basically take a bathroom break, and we'll get back on here. So it's 10:47. Let's return at 10:55. Okay.
Thank you, Your Honor.
Okay, so the chat at Law and Crime was very critical of the judge for saying she needs a bathroom break. That happens all the time. So I don't know that the producer thing is a big aspect. Everybody asks to be out pending appeal. Let's cover some super chats while they're on bathroom break. We'll let it run here during the bathroom break. I will expand myself. Jesse Waldorf, I just started Vyvanse. Thank you, Ian, for making me feel okay seeking treatment. Can nap on it during a midday lull, but it's not sleep friendly in general. That's what I found here. Jamie F, I'll be in Santa Fe around that time. I might be if the trial runs. So we'll have to see. But thank you, Jamie F. Much appreciated. Rainman YYC, thank you for the 10 gifted memberships. Sandy, thank you for the 5 gifted memberships. Leanne Pilkington, thanks for your commentary. Love listening. Thank you. Kathy Trout, YouTube isn't letting me say this. Please remember to say this isn't medical advice. Yeah, don't shoot people is it's good advice generally. Miss Derica, I'm late. Sorry, back to the beginning. Good to see you. Megan Weber, best way to beat the Sunday scaries. Thanks, Ian. Thank you. Against the Tide, please like to help Ian reach his pro bono goals. Thank you so much. Moonshine, welcome aboard. Just because, but regardless of the bullets being live, which they should never have been, Alec was not following instruction or safety rules and disregarded safety regulations and grew lax safety on that set with rushing and not pushing more cash. We'll see a lot. If this goes to trial, we'll see a lot about Baldwin's behavior, because some of the stuff like, blowing off safety meetings to go play with the guns was like, holy crap. Yellow pill NP, where I am, nursing students can only push saline through an IV. If I give a nursing student a syringe filled with a paralytic and the IV push it thinking it's saline, they will still face consequences if that kills the patient. I think that they would not face legal consequences unless it was like labeled as a paralytic or something. Damriel Kari, no weapon is you use is verified until you do. This is, I think, a big distinction between sort of the Hollywood viewpoint that I'm seeing, because I'm getting a lot of flack from actors and so forth, versus like shooters, gun owners. Great Big Geek, thank you for the YouTube membership. Much appreciated. Chelsea Rama, can't Alec's reliance on an armor and no live ammo on sets be considered intervening causes? I mean, this is one of the arguments, is that the intervening cause is the live ammo on set, that never should have occurred. There is no circumstance under which live ammo should appear on a set like this at all, right? Just, it should not happen. It should not be possible. All right, so let's, after that, the judge is going to take us over to Ms. Morrissey. That's fair. This is the thing, is we get different perspectives, right? And I noticed after a while that the movie world of this was coming at this from a very different framework, a very different mindset than we were getting from the gun owning community. And ultimately, I think a big part of this trial is going to be deciding which of us is right, legally speaking. So it'll be interesting. And I know a lot of armorers at this point, and I hope that this works out in ways that they will be okay. This whole case is ethical versus legal responsibility. It's what is the legal responsibility, because ultimately the ethics aren't going to matter here. You can't be convicted for ethics. Only what the law is. All right. Now we're going to come back with Ms. Morrissey.
Okay, so I don't have questions from your presentation at this point.
This is an interesting one. If they didn't have realistic looking weapons, and then you wouldn't have to worry about blanks or live rounds, it's not that difficult. I can tell you, when you see a movie that has all sorts of like space looking guns, like weird science fiction guns, those weird science fiction guns are almost certainly real guns, because the armorers build those weird science fiction guns around an existing gun. And this is wrong. This is just wrong here. Time to ban real guns from set. Real guns on a set are actually really safe. There have been, I think, 3 accidents in the history of ever, and they are one of the safest things. Horses are super unsafe as compared to these. Cars are super unsafe. All of these things are super unsafe. So guns are actually really safe overall. And Burl Lewis is saying, how many people have been killed on set by horses? Several, I believe. This is not something that should be like throwing out film armorers, right? This is not something that should be throwing out this kind of thing. It's just, you need it to not be Hannah Gutierrez-Reed. Hannah Gutierrez-Reed was such a screw up. Hannah Gutierrez-Reed was such a ridiculous thing. And yeah, the number of safety violations, it's insane.
However, I will later when the state finishes their response. Okay. And an interchange. Okay, go ahead. Were you finished, Mr. Ekus?
I am. Thank you, Your Honor.
All right, thank you. Go ahead, Ms. Morrissey.
Your Honor, thank you. So I want to begin by briefly addressing the initial comments by Mr. Spiro. Mr. Spiro seems to think that there's something wrong with the fact that the case was dismissed and brought back. There's absolutely nothing wrong with that. That was an independent decision made by the special prosecutors because Mr. Nikas asked us to do that.
I think I probably reached out to try to talk to him, and I don't think he called me back.
And his ask was not unreasonable. We did it because Mr. Nikas came to us and said, hey, it doesn't seem fair that this case continue to hang over my client's head while you guys are waiting for forensic testing that could be dispositive. So would you do the right thing and dismiss it without prejudice? We agreed to do that. So any complaints that the case was dismissed and brought back are an absolute misrepresentation of the history of this case.
We're going to see a lot of these allegations of misrepresentation. They're getting a little spicy with each other. They're losing a little bit of patience. They're losing a little bit of, of that. And kind of both, to be honest. So this is getting a little spicy, but this is... I don't think her criticism here is unfair because Baldwin's team did say, would you be willing to dismiss the charges while you sort this out? And she said, yes, we will. And then now they're saying, hey, you dismiss the charges. That shows some sort of bad faith. It's like, we weren't doing bad faith. We were just doing what you asked us to.
The issue with regard to the removal of the 48-hour language in the target notice, I've never fully understood what the concern here is. This isn't something nefarious. This is something that the state did because we intended to ask the court for a scheduling order under 5302.2. subsection D, which has since been removed from that rule. But it certainly was in the rule at the time that we were dealing with this because it struck us that this case was going to require that the court have enough time to consider all of the legal issues, and 48 hours was not enough time. Keeping in mind that we served Mr. Baldwin with his target notice approximately 3 weeks before the grand jury date. So we had created a situation where there was going to be plenty of time because the rule contemplates 10 days.
So she's saying we gave you extra time.
The defendant
what are you complaining
receive
about?
His target notice 10 business days before the presentation. We gave it to him 3 weeks in advance. We asked the court for a scheduling order under the rule that allowed us to do it. The court declined. We understand that. We never asked the court to give Mr. Baldwin any less than 10 days, which is what the rule contemplated. There's no problem with that. If we had included the 48-hour language in the target notice and then filed a motion to modify it, the complaint would have been that they relied on the 48-hour notice in the target letter.
She's like, there's no pleasing you people.
So we removed it, told them we removed it, told them why we removed it. There's nothing nefarious about that. We asked
Glasses
the court
adjust
to permit a minimal voir dire of the grand jury because of the tremendous amount of press coverage that the case had received. we were open to having a conversation with defense counsel to see if we could come to an agreement about, just like somewhere between 5 and 10 questions.
Me
To
too.
make sure that we had grand jurors who weren't prejudiced against either side based on all of the press coverage that they've seen. The
defense
didn't
counsel
really
don't make this into
object
thing
to that. What the defense did was they filed a motion saying, we want to ask these 100 questions. I mean, they wanted to do a voir dire that would have been a trial voir dire. And at that point in time, it was clear that we weren't going to be able to work together in order to craft a few questions to make sure that all the grand jurors were good to go.
Somebody else said
The
24
court
on
denied our motion.
for
We didn't do it.
helicopters.
There's no prejudice there. There's no problem with any of that. We asked the court to let us do something. The court said no. We respected the court's ruling. That's not evidence that a fix was in. It's not evidence that there was anything nefarious going on.
And I think this is going to be a big aspect here, which is that the defense repeatedly tries to say that there is, I think that they're trying to say that like certain things that may have been errors are like this really nefarious is the word she uses for it. And I guess it's a good word. That these errors are in, like part of some plan to deny Baldwin his rights. And I don't think that's what's going on at all. Like, I don't think she's actually engaged in anything like that, but certainly that's how the defense is trying to spin it. And that's the job of the defense.
Mr. Nickus has continued to, and Mr. Spiro supported it today. He has continued to indicate that there was a statement that they claim to be attributed to me that came out, I think, on the Today Show. That statement has never been attributed to me.
I didn't say
Mr.
it. It's
Nickus
not me.
has just continued to cite to a Today Show or an NBC News story and say that for some reason he thinks that I was the source that provided the information. He's never demonstrated that that was me. I don't think in my entire life I've ever used the phrase teaching moment. I don't think I've ever even said that in my entire life.
She's like, I don't say teaching moment. So, yeah. Do I think Hall's got off easy? Yes, but he got the same offer. That the offer Hall's got was offered to Baldwin and was offered to Hannah Gutierrez-Reed. So, yeah.
So when we filed our response to the motion to dismiss the grand jury, quite frankly, I didn't have a lot of disagreement with the controlling case law. I don't disagree that Herrera is a case that should be reviewed by the court. I don't disagree that Jones is the controlling case, both of which are actually cited in my brief. I referred to Judge Ellington's order citing Herrera and Jones. So when Mr. Nickus tells the court this morning, we didn't cite to a single case, that's not true. We talked about Herrera, we talked about Jones. We've given the court a little bit more information in our request for supplemental briefing with regard to Herrera. We cited to 31-6-11A. We cited to UJI 14-231.
He's like, look at all the case law we cited.
That is the controlling law on this issue. We discussed it. We cited it. Where we disagree with the defense is on the facts as they have presented them to the court. So as a threshold issue, the court has to find that there is bad faith on the part of the prosecution before conducting a review of the grand jury.
This, I think, is one of the things, if I recall correctly, this is one of the places where the judge is like, actually, you are wrong about this. So, yeah.
In support of bad faith,
she's having to check her notes, and her notes are off to the side. So she's having to look over each time, and it's really distracting and kind of disruptive. So
the defense seems to rely on the Herrera case, but I don't think the Herrera case is...
this is not good. She's struggling to make her argument because she's trying to find it on the computer.
Hang on, let me get to... In terms of bad faith, the Herrera case found bad faith on the part of a prosecuting attorney. But in that case, the prosecuting attorney ordered the target not to answer a direct, relevant question from a grand juror. That is not at all what happened during this grand jury.
And the defense is going to argue that it is. There's
the attorney
a bit of
also, in that case, told the grand jury that the target's testimony should not be considered because it was an impermissible attempt to make the grand jury consider the consequences of its decision to indict. That is not what happened in this case. I agree that Herrera should be reviewed by this court. But the facts, as presented, don't support a dismissal of the indictment based on Herrera.
You can see the difference in delivery and preparation, and she is she's struggling a lot more than Nikas was. Nikas had his argument. Nikas had practiced his argument. He was ready to go. Now she is a bit responding to it, like to what Nikas said, but she should have had some anticipation of what that was going to be.
Is completely distinguishable, and Herrera was cited in our brief.
If I was the judge, I'd have to think about it. I'd be inclined to not dismiss.
In the Baldwin grand jury,
but I'd have to think about it. I'm not certain.
We had witnesses who were not at all familiar with how safety protocols work on movie sets. Because
Jennifer
hardly
Kenny,
anyone knows how safety protocols work on movie sets. Detective Hancock, a grand juror.
If you want to reach out and let me know sort of your thoughts on this, justice for Miss Hutchins, absolutely. So reach out if you'd like. I'm on Twitter. You can send me a DM.
The specifics.
Love to hear from you.
Of how safety protocols work on movie sets. I decided to have another witness who actually understands how those safety protocols work answer the question. I didn't hide any information from the grand jury.
So her argument is the grand jury had questions about safety protocols. They wanted to ask Ms. Hutchins, who doesn't know anything. Or it's not Ms. Hutchins. What's her name? They wanted to ask, I'm blanking on it. Anyway, they, and she's like, I had them, I had them talk to the person who actually knows things. That's her argument here. The judge is going to have some questions.
I certainly, when I did
Hancock,
that, my
there we go.
intention,
I'm running on 3 hours of sleep.
Bad faith, was to ensure that the grand jury got information that was accurate and reliable. And they were going to get accurate and reliable information from the guy who's an expert in movie set safety, not from a Santa Fe County Sheriff's detective who doesn't know anything about set safety on movie sets. That's not an example of bad faith. Mr. Nikas has tried to convince the court that somehow there's something wrong with Mr. Carpenter's testimony, and that his testimony before the grand jury in this case is somehow supportive of a nefarious intention on the part of the prosecution. I have reviewed Mr. Carpenter's testimony from the trial. I have reviewed Mr. Carpenter's testimony from the grand jury. Carpenter's testimony in the Gutierrez trial is that the armorer is in charge of gun safety. We agree.
Cool.
He also testified to that before the grand jury. Mr. Carpenter's testimony in the grand jury was that the actor has responsibility for the firearm once it is in his hand. That is absolutely accurate. I have gone through and pointed the court numerous times.
So she's saying, listen, there's no inconsistency. I don't entirely agree with her that there's no inconsistency. In fact, I would say I kind of disagree with her that there's no inconsistency. So, yeah.
To the safety protocols for movie sets. And what they say is, the person who's holding the gun isn't supposed to point it at anyone. The person who's holding the gun is supposed to keep their finger off the trigger. The person who's holding the gun is supposed to know what their intended target is. All of those are things that Mr. Baldwin failed to do.
And the thing is that this is true. And one of the interesting things is that we've actually had the Screen Actors Guild put out multiple different versions of what safety should be. Before this accident, they say, you know, the actor has all sorts of responsibility, and they really, I'm going to be clear about why they did this. This was not to actually say that, like to establish a legal standard. It was to put fear into everybody on a movie set, right? It's to say, like, don't horseplay around. Don't do... One of the things they were probably concerned about is the guy who, you know, put the gun with blanks up to his head and pulled the trigger. That's why they had that. And then the problem is that after this shooting, they ended up making statements to be like, well, it's never the actor's responsibility. They changed their view on it because they're the Screen Actors Guild, and suddenly they had, you know, Baldwin is one of the people they represent. So is any of the other actors who could have been in Baldwin's shoes. So they changed their principles on that.
And that information was appropriately presented
A little bit
to the grand jury in this case through the testimony of Mr. Carpenter. The defense wants somehow to try to convince the court that the actor who is holding a real gun in his hand has absolutely no responsibility for what he does with that gun. And it's simply not the case. And it's not the case when you look at at Mr. Baldwin's own guidelines from the Screen Actors Guild. So we're presenting the evidence that we have that supports the charge. In addition to doing that, we presented this grand jury with lots and lots of exculpatory information about Ms. Gutierrez's failure, about the source of the live rounds. That is the proximate cause. The proximate cause issue that the grand jury absolutely needed to hear about and understand is Ms. Gutierrez put a live round in the gun. And Mr. Baldwin didn't know that there was a live round in the gun. That's proximate cause. And that was presented to the grand jury because I agree, it's exculpatory. It goes directly to the proximate cause jury instructions that they didn't have to argue with us about. We gladly presented those jury instructions to the grand jury.
She says, look, I gave them that. I gave them, like, I was trying to be fair with them. I was trying to. And one of the things she's put in her filings before is like, I'm a defense lawyer normally. Of course I was fair to, fair to you. Now, I don't have a transcript of the grand jury testimony, so we've got very different views of what happens with the grand jury, and I don't know which is correct. But she's saying, look, I told them about the armorer's responsibility, and they still decided to indict. So what do you want from me here? So that was Dave Halls. He pled out and got probation. So he is over. He's done.
And I can't imagine a world at trial where we're going to object to those. There's not bad faith here.
It's not, but the jury is, they're certainly going to try to get the jury to look at it that way.
There was no testimony at any point in time, not in the grand jury, not at the Gutierrez trial, that the actor is required to participate in the safety check with the armorer and the assistant director. Nobody ever said that. It's not true. It's his option, and he declined to take advantage of it. We are presenting the facts to the grand jury as we see them.
Now, she's going to face some tough questions from the judge at the end of this. We'll see that, because she gets grilled. And that's not something I expected to see.
With regard to Mr. Nickus in his motion goes through this series of bullet points that he believes are related to bad faith. And one of those that has been discussed today, probably the only one that's actually relevant to the grand jury, is the information or rather the interview. I wouldn't call it an interview, but I did provide the New York Times with the date of the grand jury. I've acknowledged that. I've never tried to hide that.
Okay.
Honestly, I absolutely understand that grand jury proceedings are secret, but the date of the grand jury, this isn't a federal grand jury. The date of the grand jury proceeding is given to witnesses who do not have an obligation to keep it secret. They don't sign an oath. They have no obligation to keep that secret. It is given to the target. The target can give it to his wife. He can give it to his parents. He can give it to his wife's hairdresser. He can give it to whoever he wants. The date of the proceeding, in my opinion, is not secret. But
okay, so she's basically saying you're making a big deal about secrecy, but secrecy only applies to actual secret information, and this is not secret information, so you lose, right? That's her argument here.
Best case scenario for Mr. Baldwin, let's say it absolutely is. The date specifically is something that nobody's ever supposed to know about, even though we give it to a whole bunch of people. The grand jury didn't happen on November 16th.
Even if it is secret information, I got it wrong. It didn't happen that day, so how's it a violation of secrecy if the information that went out is wrong? Okay.
The judge moved it. He moved it because he needed more time to address the legal issues, and that was the reason that we asked for a scheduling order in the first place. So the grand jury was moved from the 16th. Mr. Nickus has continued to try to argue in his pleadings, although he hasn't seemed to argue it much this morning, but he seems to argue in his pleadings that
a little bit of shade there.
After that, I again provided the grand jury date to the press. Absolutely not. That absolutely did not happen.
So she's like, yep, tough.
So, and I can tell you, Judge, it wasn't bad faith. It was just my understanding of the fact that everybody ends up with the date. A bunch of people who are not required to keep it secret get the date. And if that was a mistake, it's my mistake, and I'll take responsibility for it.
Okay.
In terms of the waiver issue, all of the cases cited by Mr. Nikas are civil cases.
This is one of the things I was noting.
But
there.
again, they presented the case law that we agree is the controlling case law. We simply disagree with their recitation of the facts. So I filed a response that was
so this is
largely...
saying I didn't waive the issue. I just didn't cite any case law because we agree on the case law. So why would I cite like to the same thing that they're citing?
My recitation of the facts. I do want to say with regard to Herrera, paragraph 20, our grand jury statutes require that the prosecuting attorney alert the grand jury to the existence of target offered evidence and do not require the prosecutor to actually present such evidence. Once alerted to target offered evidence, the grand jury remains free to decide not to hear the evidence or to hear the evidence and weigh it as it sees fit.
Now, the judge is going to ask questions about, like, listen, don't you have some kind of responsibility here to point out that, you know, that the evidence exists beyond just like, you know, don't you have some sort of obligation beyond just like, there's some evidence out there. Don't worry about it. It's not, you know, so yeah. Judge is skeptical here.
So despite that is the law in the state of New Mexico, the defense continues to argue to this court that our failure to, one, notify the grand jury of their obligation, or not their obligation, but notify the grand jury of their power to call witnesses and review documents was somehow inappropriate. And in addition to that, the argument that we didn't call their witnesses, we didn't present the testimony that they wanted us to present. We are not required to do that. We went above and beyond in this grand jury proceeding, providing to the grand jury, not only did I read the target letter in its entirety, word for word, I gave each and every...
And this is one of the things, they're like, sure, you read the target letter, but did you explain the target letter? And she's like, any explanation you wanted to put in, you could have put in. I read it exactly.
Every grand juror a copy of it. They had it the entire time we were going through the presentation. We didn't take those copies back. We left those copies with the grand jury the entire time, so that if at any point in time they wanted to reconsider and they wanted to say, hey, we'd like to hear from so-and-so, they had it with them the entire time. What I've always been a little mystified, other than reading the entire target notice and giving each and every grand juror a copy of it to read, asking if they want to take a break to consider it, giving them time to consider it, waiting for them to knock on the door, coming back into the room and saying, how do you want to proceed now that you've had time to review the target notice? And them saying, let's proceed with the witnesses you have. What, other than that, what am I supposed to do? And in this regard, if the court will indulge me, to a certain degree, the defense has misconstrued what Judge Ellington ordered when we had our hearing on January the 11th, 2024, prior to the grand jury. I would like to play just 5 minutes, a 5-minute audio of that hearing, so the court can understand exactly what Judge Ellington ordered and the back and forth that we engaged in. Would the court indulge me 5 minutes?
She's like, I need 5 minutes to read what I'm about to argue.
Mr. Nikas, Mr. Spiro, what's your position? Spiro, I'm sorry.
Yeah, I would object unless we're putting in the whole transcript, and she can submit it to the court in camera. I don't think we have to sit here and see some snippet of it, and then I have to do redirect. I would have to have the court just review it in camera if the court thinks it's necessary. I know the court has the transcript.
So it's like, can we just read this behind the scene? Like, we don't need to do this. I prefer preliminary inquiries generally, but.
And I would also add, Your Honor, that none of this was presented in the context of the opposition brief. So the request for full context, the full transcript argument on this would be highly prejudicial if it were going to be this focused and narrow.
I'm aware of the, I've certainly read the log notes and listened to the log notes of Judge Ellington's order. So make your point, Ms. Morrissey. I don't need to be refreshed. Thank you.
So the point is, Judge Ellington asked the grand jury clerk to provide refreshed copies of the grand jury orientation instructions so that the grand jurors, even though they had already had all of that information in November, even though they already understood that they could call witnesses, that they could subpoena documents, Judge Ellington had the grand jury clerk give them those instructions again so that they would be refreshed about what they can do in the grand jury, the powers that they have, the witnesses that they can call. There is no obligation on my part to start explaining to the grand jury something different than what the court has already provided them. They were provided those as a refreshment. And that explained everything that they could do. They understood their powers. I had a discussion with Judge Ellington about the fact that obviously, because this decision is coming, I think, less than a week before we're presenting the grand jury, that there would be some witnesses that we wouldn't be able to get there. We weren't going to be able to get out-of-state witnesses there. I had this entire discussion with Judge Ellington because I had concerns about it. And I asked the judge.
She's feeling a little, you can tell that she's taking this a little bit personally, because she's like, I was trying to do everything right. And why are they calling me the bad guy here?
If they want to hear from a witness and I can't get them there by the time the term ends, what's the best thing for me to do? Are we going to ask the grand jury to stay together, to come back on another day? Judge Ellington said that's a possibility. If any of these problems arise, I will be in the courthouse because I'm going to be in trial. Just come and speak to my staff. And if I need to render assistance, I'll render assistance. The grand jury never asked to hear from the witnesses.
She's like, is it my fault?
There's nothing I can do about that.
She says, I could have brought them. And if I couldn't have brought them, I could have gotten more time to bring them. What do you want from me? There's a lot of what do you want from me here? There's a lot of moments where I think it's paused because she's just staring at something.
Argument that is predicated on a bunch of civil cases. With regard to waiver, that's okay. We can just focus on the cases that the defense presented, because those are the controlling cases. And that is the controlling statute. We did everything that we were supposed to do. We went above and beyond. And I want the court to understand, at the conclusion of evidence, I reminded the grand jury that if there were any documents in Mr. Baldwin's target letter that they wanted to see, I had copies of them right there. And when I said it, I pointed to 3 bankers' boxes that were sitting behind me. They were sitting there in the room, and I pointed to them because I had copies of each and every document for all of the grand jurors, and I think there were like 22 grand jurors in the room. So not only did I tell them, knock on the door and let me know if you want to see any, I made very clear to them that they were there and that they would all have copies of them if they needed them. This is not a trial.
I'm going to put her at 1.25.
This is grand jury. They provided an alert letter. We read it. We followed all of the judge's orders.
And the judge is going to be skeptical of this, right? The judge is going to have some questions. We're going to talk about the questions there.
If the court has any questions for me, I'm happy to answer them.
I'm going to let you do your reply.
So now we're going to hear from Nikas again.
So, Your Honor, just very briefly, and then I'll turn it back over to Mr. Nikas because
I wish
directly related to his points. But
I wish
the colloquy with Judge Ellington suggested that he understood the logistic problems. That's what being a prosecutor is like. Sometimes it's not easy. You want to have a case on the last day. You don't get to fast pitch it. There's lots of options, right? One option is to have the witnesses there, one of them there, one exhibit there, right? There's nothing in the transcript about pointing at some boxes of evidence. There's nothing like that there. And there aren't any witnesses there. So what Judge Ellington is saying is, hint, hint, you might want to be careful. I know I'm going to get a motion on this, and this is a runaway case, and there's a lot of zealousy going on. You can also delay the grand jury presentation so that you're not on the last day. There's lots of options to do it. Anybody who's a seasoned prosecutor knows that. And then the other point that I would just make is where Ms. Morrissey started, which is, this wasn't nefarious, wicked, evil acts of horror. I never said that it was. I don't think this is some wicked, evil prosecutor or some horrible person. But on that day, in that grand jury, they didn't do what they should have done. It's just that simple. You're not supposed to do that when you're a prosecutor. You're not supposed to conduct yourself that way. And that's not an indictment that this court can hang their hat on.
I have just a few points, Your Honor. Our briefs address anything that the state has argued, most of what it's argued, in fact, has been waived in any event. But just a few points to illustrate some of the
Don't rely on waiver.
Where
always argue
the state has made comments that are not accurate. And ultimately, we'll hang our hat on everything else we put in our brief to demonstrate that the rest of it is consistent with these. And so, number one, the state says we don't cite any criminal cases on waiver. We only cite civil cases. That's not accurate. We cite State versus Vaughn. The standard on waiver is exactly the same for both scenarios. Number two, the state says we didn't call Detective Hancock to talk about gun safety because she didn't know about gun safety. That's why we stopped her and we actually had somebody else testify. That's not accurate. Ms. Morrissey asked Detective Hancock about what happens when the armor hands the gun off to the actor. And Detective Hancock said she's supposed to do a safety check with the actor. And ultimately, that wasn't done. So the testimony of Hancock, even though we just heard from the state, which is not knowledgeable about safety standards, the state elicited that. Number three,
they're like, that's on you.
The Herrera case, Your Honor. The Herrera case does not say when a target is giving testimony and the target is saying a certain thing and the state cuts them off. The target, because the target has a right to be there, therefore has created a scenario where an indictment must be dismissed. The outcome of that case had nothing to do with the fact that it was the target testifying. The court made very clear that when a prosecutor cuts somebody off and denies the grand jury information that they've asked for, that period full stop is an interference with the process and denies them what they're entitled to. And if Your Honor looks through the transcript and sees the number of times the state said words like, let me stop you, or I'm going to stop you, or you're going to hear this information.
The thing is, that is probably correct, but you actually see that this is part of her. This is part of how. This is like one of the mental tics she has. Like when she's dealing with a witness, she's always like, she'll ask them a question. She'll say, let me stop you. And then she'll, get them, because she's trying to often keep them focused on something. She did it like hundreds of times in the Hannah Gutierrez Reed trial. I don't think it has the meaning that he's ascribing to it, right? I don't think that he's like he's trying to say that she is, interfering with that. It's just how she, it's her what if any. So it may come back to bite her. She may have to lose that
from
one.
somebody else. It's over 20 times. Day 1, pages 20, 26, 27, 34, 88, 160. I could go on and on and on, Your Honor. This was something that happened. It was pervasive throughout the entirety of the process.
It's because it's a
and so
mental
if you look at the Herrera
beat
case
for
and
her.
basis for it, and you look at the cases we cite, we respectfully submit they require dismissal. And the state did not discuss and talk about and analyze these cases. The only reference the state made to any cases was when it said in Judge Ellington's order, where he cited Herrera and quoted Jones, Judge Ellington said such and such. There was no analysis of the case law. There were no cases cited for authorities. The state didn't address any of these issues in its brief. And so, Your Honor, we could go on and on, but Your Honor has questions. That's what's most important to us. And everything else that we've written in our brief, we believe is clear, and we simply refer to them.
It's like, please ask us the questions.
All right, thank you. First of all, I want to ask Ms. Morrissey where she's relying in Jones and Herrera on the fact that they have to demonstrate bad faith before they can get into any of these arguments.
This is where she goes, you say that it needs bad faith for everything. I don't think that's correct. The judge is going to say, like, that is just wrong.
Yes, Your Honor. It is. Hang on just one second. Give me just one moment.
Sure, take your time.
This is a place you generally don't want to be when this is a place you don't want to be when the judge is like, I want you to show me this in the law. Take your time. That's the judge saying, it ain't there, is it? You do this with witnesses sometimes where you're like, I just want to show you this. And I want to ask you where you said that. Here's the transcript. Where did you say that? And yeah. Or, here's the video. Where does that happen? Like, stop me when that happens.
Paragraph 13, I believe, Your Honor. And in addition to paragraph 13, I would also rely on 31611A. The sufficiency of the evidence upon which an indictment is returned shall not be subject to review, absent a showing of bad faith on the part of the prosecuting attorney assisting the grand jury.
Sufficiency.
Okay, so I started off asking counsel to address the two types of errors. One is, which I'm quoting from Herrera, and that's paragraph 12, challenges arising from grand jury proceedings ordinarily fall into two categories: challenges to the quality or sufficiency of the evidence before the grand jury, and structural challenges involving the manner in which the grand jury process has been conducted.
This is the distinction that Spiro and Nikos were
finish
drawing.
The paragraph 13, it says, in accordance with the statute, our courts will not entertain a target's challenge to the quality or sufficiency of the evidence presented to the grand jury unless the target demonstrates prosecutorial bad faith. And your cite to 31611 also talks about the sufficiency of the evidence upon which an indictment is returned shall not be subject to review absent a showing of bad faith. That doesn't include structural. And Mr. Nikos addressed structural right after the waiver. And so I think that the fact that you're arguing that he has to show bad faith is incorrect on other than the sufficiency of the evidence. So I don't think that that was properly addressed by you. Now,
whoops. That is the judge saying, I think you got the law wrong on this one. This little moment there is a big win for the defense. That was a big win for the defense, that little exchange. Let me cover the super chats. There's not a whole lot to catch up on, but just to keep things from backing up. Moonshine 35, is someone clueless about guns? I think they should always be checked, but I'd also be worried about someone inexperienced messing with it after a real professional checked it. Yeah, if an armorer sees you messing with the gun, you're getting booted. Katja the Frankenfurter, in some European countries, there's a little notch in the chamber, so you simply can't load a live round. Only special dummies or blanks. Interesting. SK, why is SAG guidelines treated as equal to New Mexico law? They're not. Full stop. Skeesy, shout out to my hubby. I love watching LawTube with him. Shout out to Skeesy's hubby. And Chelsea Rama, I feel weird. I believe Alex should be acquitted, but I'm also rooting for Kerry against the New York City lawyers. That I have to do it.
Well, this dog made New York City. New York City.
That's going to be a constant sort of theme on this one. I get the feeling that Ms. Morrissey didn't really think this was going to be a big thing today. She was a lot less prepared than the defense were, and she's not a lawyer who typically comes in unprepared. I think she just kind of, I think she thought this was going to be an easy hearing, and it's not.
I'm going to ask you some questions, and I'm going to ask you questions because you were the one doing the grand jury. So, I mean, you know, I may ask Mr. Baldwin's counsel, but I'm primarily focused on what occurred at the grand jury. So one of my first questions is, and I'll try to stay. Well, let's go to the information about the lack of advisement about the target. The target, you saying that reading the target alert letter went above and beyond what you were required to do, and you gave some information about it. At the very end, you even reminded them of the boxes. And I'm just wondering why you wouldn't have reminded them of the witnesses as well at that time.
You see the question she's saying. You pointed all of this, you know, to the big boxes of evidence, but why didn't you mention the witnesses? Were you hiding the witnesses? So you can see these are some critical, skeptical questions. These are questions that indicate that the judge is not 100% on side with Morrissey, which is usually what you would see after a motion to dismiss like that, right? If you saw, let's compare this to her response at the end of submissions when Bowles was making arguments to throw out the case. It was, okay, is everyone done? Cool. Bowles, you're going to, you lose. Here, she's got tough questions.
Well, the reason that I wouldn't have reminded them of the witnesses is because they had the target's alert letter in their hands the entire time. I know for a fact that they reviewed it, and you can see that from the transcript because they were actually asking about typos in it. So I understood that they had reviewed it. I understood from the hearing that we had on January.
They're asking about typos in it. It's like, pro tip, leave some typos just so that you can show people read it.
The 11th,
it's kind of a green M&M's thing there.
The clerk of the grand jury was providing them with a refreshed instruction that they had the power to request any of these witnesses. So it was my understanding from the hearing that we had on January 11th that they were being provided a refreshed instruction in that regard.
Okay, thank you. When you talk about, as we know, Judge Ellington said, make the witnesses readily available.
I mean, the other thing is you can remind people forever, right? What is the right amount of reminding? I don't know.
And in your response, you said that you would have made them readily available had the grand jurors asked, and you said if they couldn't come in person, I'd ask the grand jury judge for permission to have them appear by video testimony. But then you also said, or I would have given them interviews of pretrial interviews or investigative interviews. How can a grand juror ask questions from a transcript?
So she's saying, like, you would have offered to give them the transcripts. How's that helpful? They have questions. You can't question the transcript. So you needed to have the live witnesses available. I'm getting questions here. Green M&Ms. So I forget which band it was. One band quite famously had in their rider, their conditions for doing a show, that there was to be a bowl of M&Ms in the green room with no green M&Ms. I think it was green M&Ms. Van Halen, I'm being told by the chat. So everybody criticized them for the M&Ms thing. And the thing is, Van Halen ended up explaining the M&Ms thing, and their explanation was actually, brown M&Ms. Okay. was actually quite brilliant. They basically said, listen, our setup is complicated, and if you get it wrong, it could literally hurt or kill somebody. So we put the brown M&Ms thing in as a test. It's if you don't go through, like if there are brown M&Ms or if there's no M&Ms, then it means people aren't following instructions. And so it's an early warning sign to indicate that there might be serious problems with the safety conscious stuff, right? So it's an indicator. The brown M&Ms were a canary to see if there was a problem here. Here, I don't think that it was intended. The typos actually kind of are a bit of a canary in the sense of, does the jury notice them? There was another famous similar detail check with the film Good Will Hunting. When they were making Good Will Hunting, they were worried that too many people would want to produce Good Will Hunting solely on the basis that like Robin Williams was involved. And so they buried a sex scene in the script. And the whole reason for that was that when they had somebody come back to them and they said, hey, we love the movie, but you're going to have to cut the sex scene. That's a problem. Like that makes no sense. They were like, yes, okay, we want to go with you because you actually read it. You didn't just look at the names on the cover sheet. So that's kind of the typos issue here. So yeah.
I agree with you, Your Honor. And this was one of the things that was discussed during the hearing with Judge Ellington. I believe it was the same hearing on January 11th, was the fact that some of the witness testimony that Mr. Nickus wanted to
and then they buried it in there.
Present was directly from the interviews. So for example, what Mr. Nickus would do, and you can see in his notice and his alert letter, he provided to the court these exhibits that were summations of the police report. So for example, he provided the court with a copy of Detective Hancock's supplemental report that described her interview of Jensen Ackles. And so I had a discussion.
Everybody loves Jensen Ackles. It's funny. I did a review of Jensen Ackles' police interview, and I had people who were like angry before I did the review because they're like, "You're not going after Jensen Ackles, are you?" I'm like, "It depends on what he says."
With the court about if what
I didn't hate
the defense
his police
is
interview.
asking for, and they certainly were not asking for this for every single witness. So I didn't think that this was going to fly with every single witness. But if what they were asking for was this witness's testimony as it was given to Detective Hancock or Detective Cano, and we had those audio recordings, then we don't need to bring that person from California to have them talk about that in front of the grand jury. We discussed that.
Because just about everybody in Hollywood is going to be in California normally.
With Judge Ellington, and he indicated, yes, that would be a possibility. So I do agree with the court that when presenting the testimony that way, if the grand jury had questions, they would be having to pose those questions to Detective Hancock as the person who did the interview. And I want the court to know that I actually spoke to other prosecutors, primarily in the 2nd Judicial District, to ask if they had ever presented witness testimony over video, Zoom or Google Meets, and they indicated that they do it all the time. So So this is just, we're watching the hearing for the motion to dismiss. Alec Baldwin is asking for the case against him to be thrown out on the basis of irregularities and problems with the grand jury. And right now, Morrissey is trying to sort of present all of this. Hello, Sandy Beach. So yeah, this is, Morrissey is saying, I talked to other people. They said Zoom is fine. I actually think there is no problem with Zoom here. So I don't see a Zoom issue. actually taken steps to ensure that I had a leg to stand on with regard to having witnesses testify via video, understanding grand jury secrecy, that one of the things that we would have to do if we did that, if Judge Ellington approved it, would have been having the witness under oath testify that they were alone and that they weren't recording, and et cetera, to try to ensure grand jury secrecy.
This happens all the time. People do video conferencing stuff all the time. I don't have a problem with, so she's saying, like, listen, the witnesses weren't there in person, but why is that an issue? We can do this over Zoom, over Google Meets, over whatever. And I'm going, I don't actually disagree with her. In fact, I would say that if you want to keep this proceeding secret, you're going to do a much, much better job of that, having many of these witnesses testify via, Zoom or Google Meets or whatever, rather than doing it in person, especially if you wanted to, do something like, let's say they wanted to bring in Jensen Ackles. Do you think that, Ackles, do you think that, that the paparazzi and so forth really keep track of where he's going, and that if suddenly he was flying out to New Mexico, they would have taken note? You better believe it. But the same applies to Seth Kenney and various others, because the media would absolutely pick up on them going to, and them flying. So I actually think if you're worried about the secrecy, the Zoom meeting really might have been the better way. And we ask witnesses all the time, every witness that testifies in, via Zoom, and there were several who did that in this proceeding. We had several, you get them to acknowledge that they don't have their, a person there holding up signs telling them what to say, right? So, yeah.
So I was trying to come up with ways of presenting some of the testimony. Now, with regard to some of the witnesses, though, I was not at all opposed to having them there in person. The problem with the situation was we only had a week from January the 11th. We didn't know how Judge Ellington was going to rule. So,
we only had a week. Well, that's kind of the defense's point, though.
So on January the 11th, we get the ruling. And then at that point in time, I'm trying to figure out what to do with these out-of-state witnesses.
I don't think we need
true,
fight
I didn't
bot
have
at
Sarah
this point.
Zachary sitting in the hallway. But I could get her there, and I knew that I could get her there because I had talked to her attorneys on the phone.
She's like, she was available. She doesn't have to be in the hallway.
About grand jury. So for the local witnesses, the witnesses that were local, that the defendant wanted the state to make available, I absolutely was intending to have them there in person. It was the out-of-state witnesses that I was trying to figure out how I could juggle those. So I was hoping that if the testimony was requested, we would be able to do it either from video interviews, understanding, Your Honor, that there may be an issue with regard to grand jury questions, or just having them present by video, which my understanding is in the second is routine. So that was my plan at the time.
I'm curious as to that you didn't reach out to any of these witnesses other than what you just said, Sarah Zachary, to just sort of touch base with them, see if they were available even by video.
I'm not sure.
That's a pretty critical question, right?
I actually don't agree that I didn't reach out to them to see if they were available. I believe I had a conversation with Mr. Souza. I did not have a conversation with Mr. Halls, but that's because he was represented by counsel. And his attorney was historically very difficult to get a hold of. So I was going to have to try to manage that as best I could through Judge Ellington if the grand jury wanted to hear from Dave Halls.
That just undercut her entire point, right? They're available, except this guy who's totally not available.
I don't think that it was just Sarah Zachary. I'd have to go back and look at all of the witnesses that the defense asked that we present because I did make phone calls to kind of let people know that this may be an issue that would be coming up. I specifically spoke to Mr. Winger with regard to Ms. Zachary. Do you want me to go through the witnesses? I'll have to pull up their alert letter. I can go through each and every witness.
Well, you never responded that you did. That they said you didn't, and you didn't respond that you did. And there's 7 of them.
So that's a waiver question, right? They said you didn't talk to them. Why didn't you respond? Like, why didn't you put that in your filings?
Sure.
I'm just asking. I mean, if you're saying that you did,
Sure is not a great response to that question.
I mean, I'm just curious as to, you're saying, well, I was trying to coordinate this, and I knew that Zachary, I get, and Hall's attorney is pretty difficult to get a hold of. Then I'm curious as to, even by video, how you needed to. Common sense tells me you should have reached out ahead of time. That's all.
Oh, I agree with you. And
When the judge says common sense says you should have done a thing and you didn't do the thing, that's not great for you in a hearing. It's just one of those danger signs. Like when the snake makes the shaky noises, it's like that.
and I'm telling you that I think with regard to Mr. Halls, I reached out to these people. But for
these people,
for this,
who are you calling these
people? Let me
people?
look at specifically all of the witnesses and let me address the court's inquiry here. I have so many documents in front of me. I'm trying to find
Take your time.
I'm trying to find their alert letter. I had it in front of me.
And we've got 2,300 people in chat. If you haven't, slam the like button, hit the subscribe, all of those good things. All of those are free, so there's no excuse not to do them, unless you don't want to. In which case, I have no way to force you.
Here, I'm getting there.
We've got Rainman YYC saying, I think the prosecutor is probably very accustomed to rubber stamp denial of motion to dismiss. I would agree, except she's normally also a defense lawyer. So, yeah. All right, let's
Souza. Mr. Souza was extremely cooperative with me. He made himself available anytime I wanted to speak with him. I believe that I would have had absolutely no issue having Mr. Souza appear via video.
So Souza was easy. Okay.
The next witness number 2, Mr. Halls, I've explained that. He's always difficult because we have to go through his attorney and she can sometimes be somewhat non-responsive. Ms. Zachary, witness number 3, I've addressed that. Witness number 4, Ryan Smith. I did not reach out to Ryan Smith. He, as a producer for Rust Productions, I believe that technically he is currently represented by Ryan Villa. Ryan Villa has been extremely cooperative with me, and I expected that if the grand jury wanted to hear from Ryan Smith, I would have been able to present his testimony through the cooperation of Mr. Villa.
I would have checked that because it's entirely possible. Like when she's saying, I believe he's represented, it's entirely possible she reaches out to Ryan Villa and he's like, I don't assist him on this matter. Nope.
Hancock was there. Of course,
I would have done the checking
to ask her any questions that they wanted that she could have had the answers to. Witness number 6, Joel Cano, absolutely. He's with the sheriff's department. I could have had him there within 10 minutes.
Yeah, that one I get. The sheriff, boom, that's easy. Are you in the middle of a murder? Nope. Okay, get your butt over here.
Mr. Schilling, I did not reach out to Mr. Schilling, but
this is a good one. Do you ever worry a reflection in your glasses could reveal private information? I don't wear glasses when I'm in front of a video screen. I do actually wear glasses. Like, these are my glasses. So I've had some people who are like, Runkle wears glasses? Yes. I just don't do it on a video screen. But if I was going to do it on a video screen, you better believe that there would be nothing on my video screen that would be potentially a problem. Right? Same thing like when you're in court, your laptop like you have a clean laptop. You don't use that laptop for anything else.
But I absolutely had full confidence that if the grand jury wanted to hear from Mr. Schilling,
I can actually see some stuff in her glasses.
although his testimony, I can't imagine would have been highly relevant to them. I would have been able to get.
It's not ring lights that I'm seeing in that. It's screens, but
Mr. Schilling there. I think Mr. Schilling
or maybe
lives in
Windows.
Santa Fe. He would have been very, very easy for me to contact and have him there. He's retired, and he is generally available.
I know EDB's got special lenses.
And I want the court to know that, one of the reasons that we read the target's alert letter at the beginning of the grand jury is so that if they say, okay, we've met and we've conferred.
I will say that the prosecution wasn't worried when they got in. I suspect that the prosecution is a lot more worried now. Yeah.
And we want to hear from these 3 witnesses, or we want to hear from all 7. Then I can tell my investigator, while I'm presenting the witnesses that we have here, you got to go get these other guys. You got to call Mr. Winger and you got to tell him that Sarah Zachary needs to be here. And you need to go knock on Mr. Schilling's door if he doesn't answer his phone. So we would have had time to do those things. We knew that this grand jury was going to take quite a long time. I know that the defense has continued to argue that this was something that we rushed through. As this court knows, it's almost unheard of to have a 1.5 day long grand jury proceeding. We didn't rush through anything. We spent a long time. We had every single grand juror come back the following day. In terms of
what do you want from us?
Let's say worst case scenario. Worst case scenario.
There's a lot of what do you want from me here in this proceeding?
The grand jury wants to hear from a witness that I can't get there. So I had a specific conversation with Judge Ellington. If that worst case scenario arises, what do? Do we ask the grand jury as a group to agree to come back at a later date? And he indicated that was a possibility. Now, the other possibility is that if the grand jury wants to hear from a target's witness, and for some reason we can't get them there, and this didn't happen, we can, if we choose to, start the process over. There's no way that we would have, if we had a grand jury that said, I want to hear from Dave Halls, and I can't get Dave Halls there for some reason, I'm not going to continue with this grand jury proceeding and just have them indict him and come to the court and say, I couldn't get a hold of Dave Halls. That's not how this works.
She's like, I'm going to make it happen.
We would have just had to have dismissed it, and we would have had to issue a new target notice and start over. And at that point in time, we would have had a much better idea about what the courts.
She says, yeah, the plan is we'll get Dave Halls or we'll toss it.
Ruling was going to be. We didn't know the court's ruling until January 11th, but if we had to dismiss it and start over, which we absolutely were contemplating could be a possibility, we were willing to do that. We were never going to have a grand jury issue a ruling if they wanted to hear from a defense witness and we couldn't get that person there. Absolutely.
I'm just going to say we are seeing a lot of Carrie Morrissey talking after the arguments. Like, we had the defense argument, we had Morrissey, we had the defense reply. She is now having to respond a lot. This is way more talking than the prosecutor should have to be doing at this point. And this is not a good sign for the prosecutor. When I say that Baldwin's team has like a 30% chance of winning this, that is exceptional. This is a bad place for Ms. Morrissey to be.
Absolutely not.
She's on her back heels.
I have one more question on with respect to the target letter. So, as an aide to the grand jury, and I remember listening to the transcript, and you said,
now the thing she's hoping at this point that the judge is asking these questions in order to paper her ruling and do a better ruling and to address all of these points in a ruling. But I would be worried if I was Ms. Morrissey that I'd be worried that that it might come back against her. 30% would be a terrible gamble. It's way better than 0%. So sometimes 30% is really moving the needle. If like right now, I have a 0% chance of getting $1 billion. if there was something I could do today to give me a 30% chance of getting $1 billion, you better believe I'd be like, end stream, we're going to go do that. So, yeah.
After you read the target letter, you said, we have witnesses available now. And you emphasized in your tone, now. And then you stopped and told them, go ahead and read it among yourselves and things. Why would you not just at that time? You're telling me that you, in your response, you said it's not your duty. All you have to do is alert them. And then I asked you today, and you're saying, well, they were getting, they were told.
I'm not sure what the judge is going with
jurors, here. Judge Ellington instructed the jurors to get another copy of that, their duty, the duty. I'm
not sure where she's going
about
here.
Their duties, and then, and so that, I think that's, I don't want to misstate, but I think that's the sum total. So.
Sure, but we're not an NBA team. Like, that's not how this works. If you move the needle from 0 to 30%, that's a great day for that. Again, your sports analogies just don't make sense. If you want a sports analogy, let's say you pull some random guy off the street to fight, I don't know, Mike Tyson in his prime. If that guy is up to a 30% chance of winning, then you're very happy. Like, that guy's having a very good day. That guy's a formidable opponent. So,
as an aide to the grand jury, I'm just curious as to when they were seeing typos, did you not feel as an aide that you might let them know that you could get them there? That's why I asked you about the boxes at the end, because you went to the boxes at the end. You said, we've got the boxes here, but you didn't mention the witnesses. So,
but this seems to contradict what she said, because if, like, the judge's question here appears to be self-contradictory, because if they're saying Carrie Morrissey says we have the witnesses here, then, like, okay, what's the issue there, right? What's the issue with the reminder if you've got that? I'm not
just
sure.
Curious as to, as an aide to the grand jury, why you just didn't, what would have been what was the motivation, or what would have been the harm of just not saying, and you know what, I can get them here if you need them.
An appellate lawyer,
to that effect. Just make them a little more schooled in what they were. Do you stand by that? It's not your duty, basically.
See, this is the thing. The judge is asking, what would the harm be? That isn't necessarily the issue, right? That isn't the, it isn't what's the harm. Is there's always something that is better that you could do, right? So yeah.
I stand by that it's not my duty because the law and the case law doesn't require me to do it, but I don't want the court to feel like there were things that we were unwilling to do because we were kind of engaging in some kind of gamesmanship, like, if the law doesn't require me to do it, I'm not going to do it. My honest belief at the time was the judge has provided them today with the refreshed instructions about their duties.
Her honest belief goes to bad faith issues.
In time to believe that they were confused about whether or not they could ask to hear from any of these witnesses. If Judge Ellington hadn't specifically asked that instruction be provided to the grand jurors again, because it was provided to them in orientation and he had them refreshed, possibly I would have handled it differently. But because he did that, I didn't believe that it was necessary.
Do you know whether they got that?
We haven't seen the evidence yet, so...
Do you know whether they got that?
I was assuming that when Judge Ellington, and that was actually part of the audio that I wanted to play, when Judge Ellington instructed, I think he said Ms. Hurtado, I think that's Ruth.
If Baldwin is convicted, it'll almost certainly be on the basis that Baldwin provided a whole bunch of statements. The best witness against Baldwin, I expect, will be Baldwin himself. So
he instructed her to provide those. I had every reason to believe that she was going to do that. She was on the call. So when we had the hearing on January the 11th, there were several court employees that were on the video hearing, and she was one of them. So the court specifically told her during the hearing. The court didn't say, this is what I'm gonna do. He told her during the hearing, this is what you need to do. I assumed that she would have followed his instructions. I had no reason to believe that she wouldn't have done that.
Okay, I am aware of that. I did listen to that. I want to get into what was raised about asking the witnesses questions. In the beginning, you tell the grand jurors that this is how we're gonna do it. I'm gonna ask questions of the witnesses, and then you can ask questions, and I'm gonna interrupt and say you can't answer that question if I consider it to be not a lawful question, and I may have them rephrase the question. And so, got my notes here. So, having gone.
The judge is also very prepared. You can tell she's read through things in a lot of detail. I said before, not every judge will be prepared. She is prepared.
Prove the transcripts. I'm in Herrera and talking about how Herrera says, and so you're honing in on the target. You seem to be honing in on the target in Herrera in Herrera it says, by preventing the target from answering a direct relevant question from a grand juror, the prosecuting attorney interfered with the grand jury's statutory duty to make an independent inquiry into the evidence supporting a determination of probable cause. So I think you've said two things, and please correct me if I'm wrong, because I've been, taking notes, but I'm not a transcriber. So, you talked about that it was the target in that case, and you seem to make a distinction between the appellate court saying that that they interfered because they wouldn't let the target answer the question. But then you also said that that you came well within Herrera, and so that you didn't interfere with
The
their
judge
ability
is
to ask
skeptical.
questions. So I just need clarification. Are you interpreting Herrera to mean that the appellate court based it on the fact that the target was interrupted from answering the question versus another witness of the state?
I don't know that the judge is going to accept this as a distinction.
Judge, the only thing that I can say is when we're looking at cases and we're distinguishing cases, looking at the facts of the case, that's what we look at to see if it's distinguishable. I don't know what the Court of Appeals would do if it wasn't the target. What I can tell you is that I think that depending on the substance of the testimony that's coming out, the Court of Appeals may handle it differently because the target has a right to testify. So I think that is a difference. The target has a legal right to testify. The target is the only person who has a legal right to testify before the grand.
However, the grand jury has a right to make these inquiries. So,
grand jury. So I think it's entirely possible that the higher courts would treat that somewhat differently depending on what the substance of the testimony was. And again, it was my intention not to prevent the grand jury from getting the information. I just wanted the grand jury to get accurate information. And
the thing is the court might have a different view of accurate versus favorable, right? Did you shape the evidence the jury would hear in order to get the indictment?
I had concerns that a police detective wasn't going to give accurate information about safety protocols for guns on movie sets because she's never worked on one. And I certainly would submit to the court that that's not bad faith.
You know what I would have done? I would have put the witness up there to say, I've never worked on a movie set. I'm not the right person to ask. Get the witness to say it, right? I think this is where she's in weaker territory.
That's me trying to make sure that the grand jury doesn't get confused by getting inaccurate information.
Yeah.
Okay, so it did involve the target, but it said it's not the target. I don't think Herrera was focusing on the target's right. I think Herrera was focusing on the grand jury's ability to ask questions without interference. It says, by preventing so-and-so from answering a direct, relevant question from a grand juror, the prosecuting attorney interfered with the grand jury's statutory duty to make an independent inquiry into it. So I noticed that Corporal Hancock was able to answer several questions, and they were about about the firearm. They were about she was able to ask questions about.
So the judge is again being pretty skeptical here.
Sorry. Okay. So they're asking questions like,
she's got the transcript ready. She knows the transcript. She's just trying to find the right
live
page.
rounds. They were all in different places. One was in the actual gun that was used, and Hancock says yes. There wasn't another one in the gun. Corporal Hancock answers that. And then they're talking about were you able to get all of them back? Yes. The gun was already unloaded when we got there. And then they're asking her questions, and you say, can I try to help? And you go along. But then the first time you interrupt a juror is with Corporal Hancock is when one of the jurors asks if the bottom line is the response.
Oh,
it's a very direct question. And so you're going to tell me that she could not have answered this. And so the bottom line is the responsibility of making sure these guns, these bullets are not live, are up to what? David Halls and Hannah? And you did not let her answer that question. You said, we are going to have another witness address those issues for you. We have an expert who works on movie sets, and he's going to answer those questions for you if that's okay. And so my question is, she was the lead investigator on the
judge is very skeptical of the defense right now
on the case. Her testimony shows that she could have answered that question, and you would not let the grand juror get the question from Ms. Hancock.
If I'm the defense, seeing this line of questioning, I'm feeling pretty happy.
Why is that not what Herrera says you can't do?
So
she's like, explain to me why I shouldn't rule against you. This is not a question you want to get as a lawyer. Explain why I shouldn't rule against you.
What Herrera, in my reading of Herrera.
Now, I will note, I went over my Supreme Court appearance. I had Supreme Court justices ask me basically the same thing. Explain to me why this isn't, whatever issue, like explain to me why I shouldn't rule against you on this issue. Oh yes, sorry. The judge is skeptical of the prosecutor. Judge is skeptical of Ms. Morrissey right now.
The way that
I'm not sure what I said there.
Is the grand jury was prevented from getting the answers to the questions. I did not prevent the grand jury from getting the answers to the questions. I made sure that the grand jury got the answers to their questions.
I don't like this argument. I don't like it. And I mean, I think my position on Baldwin's been pretty clear, right? But I don't like this answer because the answer to the question is from the witness they want to ask it from, not from the witness you want them to ask it from. So I have some issues with this answer.
From the witness with the most experience.
But that's not your choice.
And I want to back up because, Judge, what you indicated in terms of all of the questions that Detective Hancock did answer, those all pertain to her criminal investigation. Where the guns were, where the bullets were, where did they recover all of them? Those all pertain to her criminal investigation. My concern was that Detective Hancock didn't understand, or perhaps didn't recall what she had been told because so much time had passed since the time that she did her interviews.
Then let her say that, right? Let her answer those things.
The very specific way that the safety protocol takes place between the armorer and the assistant director. So I presented that information to.
I could see the court going either way, right? Like, I think normally the answer would be that the witness can answer that, you know, that they're not the right person. If she loses, and again, I think 70% chance this goes to trial. If she loses, this is where she loses.
To the grand jury, I had their question answered, and my expert absolutely said, the safety check is a safety check that takes place between the armorer and the assistant director. He did not say that it took place with the actor in terms of that initial safety check. So I think that there is a very stark difference.
I'll tell you what I hate about Google Meet. When I fire up Google Meet redoes the settings for my camera. So Google Meet manually resets my camera every time, and I hate it because then I have to fix
what happened in
my streaming
Herrera
settings.
and what happened in this case, especially when we're talking about bad faith, because my intention was to get them the most accurate and reliable information. And having a police detective who's never worked on a movie set try to give some kind of a detailed explanation about the exact manner in which this safety inspection is supposed to happen was concerning to me. And I also want the court to know that the reason that this death occurred is because the safety protocols were not followed.
Taking it back up to
So
125.
during her investigation, what Detective Hancock learned was the way not to do things. Detective Hancock never talked to, I don't think Hancock ever interviewed any of the crew members and asked the experienced crew members how the safety protocols were supposed to work in a way that wasn't this distorted.
So basically she's saying that she learned how to do it wrong, but not how to do it right. And the thing is how to do it right versus how to do it wrong. The how to do it right is a far more complicated question. Let's say I've got a pilot who, you know, I don't know, something obvious. They forget to lower the landing gear in the landing and they crash the plane that way, right? Okay. It's real easy to get an aviation expert to stand up and say, you need to have the landing gear down to land the plane, right? Super easy. In order to actually explain all of the steps required for landing a plane is going to take a lot longer. So, yeah.
Way that happened on this movie set. So it wasn't necessarily that I didn't want her to give the information. In fact, I can tell you it wasn't at all that I didn't want her to give the information to the grand jury. Detective Hancock got a bunch of information from people about the way not to do things. That's the reason that Halayna Hutchins died. So I actually didn't believe that she fully understood the way that things are supposed to happen, because the sheriff's department doesn't go hire an expert and get a teaching lesson in how these things are actually supposed to happen. She got her information about how things are supposed to happen from the three people who didn't follow the rules, that being Hannah Gutierrez, Dave Halls, and Mr. Baldwin. She didn't conduct any of the other interviews with the crew who would have been able to tell her, had they been asked, this is the way this is supposed to happen. So I had a good faith basis to believe that she only understood how it's not supposed to happen and didn't understand how it's actually supposed to happen.
Well, to that point, a couple of things. Well, first of all,
But then
Corporal
wouldn't your
Hancock
witness just
interviewed
be able to
Jason
say
Ackles.
that?
And in that interview, he had different information about safety protocols on movie sets, would that have been exculpatory information?
I'd have to review it. Do you want me to review it now? I'm
No,
happy
no.
to. Okay.
I've reviewed that interview. I don't think the Ackles interview. I don't think that the Ackles interview is exculpatory for Baldwin. I think that actually the Ackles interview is harmful to Baldwin. So yeah.
So here's, I'm just saying she did have some information, I think, but in any event, when you're saying, so you're saying she was not
Yeah,
the best
some
witness
information.
to answer that question, or she wasn't capable of answering that question given her limited, she didn't know what the best practices were. Is that correct?
That's correct.
Okay, well, so, but in other,
So she, this could have been a situation where you see the judge could have said, okay, she doesn't have the ability to, to check this, and just accepted that. But then she's pushing back. There's more pushing back.
another ones where you go,
Yep. Still going. We're going to go through this whole thing.
this is, I think this is Mr. Rice. Or is it, yeah, I think it's Mr. Rice. And you say on Exhibit 20, page 86, and it says, looking back at the alert letter, there's a notation that Sarah Zachary, the prop master for the film, was also the supervisor for Hannah Reed. But nobody's talking about her playing this. So you know where I'm going. Go ahead. And you say, you interrupt her and you say, I don't know if he's familiar enough with that, with the relationship between the prop master and the armorer to answer that question. But we have a witness sitting out there who may be able to answer it. If we can bring back Mr. Looper back, if you want us to. And the juror says, my biggest part of the question is, she was also responsible for procuring firearms and ammunition for a third party, not just Hannah. And then you said, understood, let me back up for a moment. And instead of asking him about procuring firearms, you say, do you have any information about the firearms training or firearm familiarity with Sarah Zachary? And you do that, but then later on, even though you say, this is not he's not familiar, I don't think he's familiar enough with this, you do end up asking him after, maybe 3 minutes later, do you know about whether she was responsible for procuring? And he answered it. And so my point is that you decided that she wasn't the best one. You said, we've got another witness to do this. But then we have an example here where you're saying, I don't think he's familiar enough with it, but then you let him answer the question, which you just asked the question of the juror. I can read that into the record if you want.
I just want to follow where you are so that I can respond.
It's page 86. It's page 86 of Exhibit 19, and it says.
Hang on, just a second. Let me catch up.
20. It's 20.
Page 20.
No, it's Exhibit 20.
Okay, I have Exhibit 20 in front of me.
Okay, and it says on page 86, you say, she's asking a question, and you say,
the judge is basically impeaching her with the transcript. This is a bad place to be for a lawyer.
This is.
But okay, so you say I don't think he's familiar enough. You say we can bring in somebody else. You ask her a different question from procuring. You ask about training, but then later on, you finally get to it and you say, on page 87, line 18, and in terms of Mrs. Zachary, what is your understanding of where she procured the guns? So my point is that I don't understand how you can say, there was a better witness at this, so I just said there's a better witness with Hancock. And then with Wright, you say, I don't think he's familiar with it. But then you ask the question anyway. I don't understand why the grand juror couldn't ask Ms. Hancock the question and tell the grand juror herself that she couldn't answer it. Why were you telling the grand juror that she couldn't answer it?
So first
That's
of all,
a very
in terms
good
of what
question.
you're speaking about with regard to Mr. Rice, I would need just a moment to review that.
Okay.
If that's okay.
She's like, have your
because I
moment.
think that's going to be pertinent to my answer. So
Absolutely.
I'm on 86, and in fact, Judge, I already have that portion highlighted.
Like, this is the thing. This is unexpected for what I would see from, from these kinds of proceedings. So if I'm Morrissey, I'm worried about this. That doesn't mean she's going to lose this, but I would still be concerned, right?
Okay, so let me kind of describe what was happening here, at least in my mind. So the initial question on 86 that is asked by the juror, the grand juror says, looking back at the alert letter, there's a notation that Sarah Zachary, the prop master for the film, was also the supervisor for Hannah Reed, but nobody's talking about her play in this. So you know where I'm going, go ahead. And I don't believe I interrupted her. And I said, I don't know if he's familiar enough with that, with the relationship between the prop master and the armorer to answer that question. And the issue that's going on in my mind is Mr. Rice, who has also never worked on a movie set, familiar with whether or not the prop master is the supervisor of the armorer when it comes to the armorer's responsibility for gun safety. So what I'm thinking in my mind at that point in time is my investigator can't answer that because he's never worked on a movie set. Then things change because the grand juror says she clarifies her question. My biggest part of the question, if she was also responsible for procuring firearms and ammunition from a third party. When she clarified her question in that regard about where the firearms and the ammunition are coming from, and at this point, I understand she's not asking about the relationship as it pertains to who can tell the armorer what the armorer can and cannot do with guns. She clarifies the question. When she clarifies it, I realize he can answer it. He actually does know the answer to that. He knows that Sarah Zachary got the guns and she got some other ammunition from Seth Kinney. So at that point in time, I say, oh, okay, now that you've clarified your question, I mean, I didn't say it, but that's what's going on in my mind. He can go ahead and answer. So I let him go ahead and answer when she clarified it, and I understood that he did have the knowledge and experience to answer that specific question.
So she's really
Judge, I have
trying
to tell you, if I asked Detective Hancock,
this feels a little bit like salami slicing here, like trying to slice the issue real thin. So yeah, I don't know, right? I got some concerns, right? And so we'll have to see.
Now to give us a detailed explanation of the way that safety protocols on a movie set are supposed to work, not the way they're not supposed to work. I don't believe I could get a reliable answer out of her. And while I understand the court's concerns, I want the court to understand that all I was trying to do was get the most accurate information before the grand jury. And everything that Mr. Carpenter said is absolutely accurate about the way that safety protocols on movie sets are supposed to work.
Thank you. I appreciate that. I just have one more question. So the rule on grand jury proceedings 5-302.2, it talks about instructions to the grand jury. And of course, elements and defenses as well.
When she says I just have one more question, I got like serious Columbo vibes here.
But the second requirement is the prosecuting attorney shall provide the grand jury with other instructions that are necessary to the fair consideration by the grand jury of the issues presented. And because it seems to me that Mr. Carpenter was provided opinion testimony, which is true. An expert can rely on that. And I know that they weren't put in as experts because it's not a trial, but you're basically indicating that you relied on him for this kind of testimony. You've got Mr. Hagen there. I'm wondering why you didn't provide that instruction to the jury so they could the credibility instruction on witness credibility or opinion testimony instructions.
It didn't occur to me. It didn't occur to me to provide that. And the defense understood the kind of testimony that we were going to elicit. It absolutely did not occur to me to give the credibility instruction.
She's like, I didn't think of it, and the defense didn't tell us that it was an issue either. So, yep. I'm looking at a New Mexico quarter right now. Oh, cool.
It didn't occur to me until this moment, Your Honor.
Okay. Those are all the questions I have, and thank you for being patient with me and answering them.
If you would permit me, Judge, because I have this morning had to deal with Mr. Spiro and Mr. Nickus, would you give me 60 seconds to confer with my co-counsel? I'm not going to have to address the court.
Absolutely. Yes.
Let me confer. Thank you.
Absolutely. Yes.
Judge is, of course, going to give that. but we're going to skip through it as much as we can. Where is it that we see her start up again?
Anything else, Ms. Morrissey?
Yeah. So I want to make clear that what we're arguing right now in terms of witness testimony, this goes to the sufficiency of the evidence. I believe, though, that their argument.
Okay, so you want to answer it as sufficiency of the evidence? Because Herrera was structural.
That
the judge is like,
Herrera
are you
was
sure?
Structural because it was dealing with a jury instruction. And I believe that's proper. So in terms of when we're dealing with jury instructions, that is a structural defect. So that comes in under subsection B of the statute. In terms of sufficiency of the evidence, which is what we're talking about right now, this requires a showing of bad faith. So I agree with you that Herrera was talking about a structural defect, but that's because it went directly to a jury instruction.
I don't know that she's going to succeed on this argument.
Of the evidence, they have to demonstrate bad faith, and I think that this is clarified in State v. Yaw, that specifically indicates that challenges pursuant to 316-11B, 316-11B requires a showing of bad faith. And I'm looking at paragraph 8 of State versus Yaw.
Okay, anything else? Oh,
No, Your
sorry.
Honor.
Well,
No, that's
yeah, okay. Well, I think it's
Your Honor, if I could just 60 last seconds on just some quick comments that just of things that come up. I know the court's been patient and
okay.
I appreciate it. Yeah, I just wanted to just very quickly, Ms. Morrissey started by saying, we had this plan that if this didn't all work out, we just dismiss the case and start over, right? If this whole, there's obviously, this is the problem with the waiver issues. There's no contemporaneous records that was actually what was going on. And you're right, it's not that big of a deal. The court can dismiss this. If she thinks she should give this a third try, she could. But I just found that to be a remarkable comment. And of course, we've had the opportunity to talk to the witnesses and the lawyers, some of whom Ms. Morrissey was kind of recreating as she was live being questioned by you, Your Honor. And even just now, they're confirming she never contacted them. Mr. Hall's lawyer confirms never was contacted about the grand jury. Mr. Sousa's lawyer previously commented not contacted. In addition, the court should know we served a discovery request. We said any communications with any witnesses, okay? Show me one email, one internal, anything, saying, hey, we've got a grand jury.
This is the defense. Defense is excited. Defense is eager. Defense is like, we're going to try to ram this home to try to, so yeah.
In a week. The way this is
I'm slowing them down to regular speed because at 125%, at 125%, he looks like he's on coke, and he's not. It's just he's a faster talker than everyone else because everyone else is has a slower cadence. So sped up, he just is like, woof.
You hit him with a subpoena, they come to the grand jury, or you have them on standby and you talk to them. This isn't how you're supposed to do it. Period. And this is why the rest of it happens, right? And the grand jurors, they don't know what's going on. They're looking at typos. They call it a warrant letter. And the fact that there may have been a repeating of the very generic instructions that Judge Ellington was right to provide them, Judge Ellington saw it. He said, we're in the last day. They've never seen an alert letter. You have the obligation. You have the obligation. This is a homicide case. And by the way, in Ulibarri, the indictment was dismissed even though the grand jurors were presented with the generic sort of instructions. And so the final thing that I will just simply say is it was very interesting.
What am I doing? What am I doing here? Why is this guy doing
Ms. Morrissey, Ms. Morrissey, please don't interrupt him. Okay.
Yeah, yeah.
Okay, if you want to respond, I'll give you three minutes, but go ahead. Let me finish. Let him finish.
So, and then this was frankly the most remarkable part. The idea that it was going to be video testimony. This is what she purports to be her idea at the time, or read the police reports. You see, because she has to answer Your Honor's questions. She can't answer, so there's no good answer, right? So she says, read the police reports, which is, of course, hearsay. It's the lead detective, the lead investigator testifying through a document as to hearsay, right? She has no choice, but she's backed into a corner. She has to say that. Then when she has the answer for the next issue, she says, no. Hancock and Rice, they can't be asked to testify about things that they learned from other people. I mean, the story doesn't work, doesn't check out, doesn't pass the laugh test. And so, of course, she
when he's saying like doesn't pass the laugh test, it's because he thinks he's got the cards, and she is very she's rattled. She's upset with how they're characterizing her, and I think she's fair to be a little upset by that, but still
cuts them off. And if you look at all the cuttings off, the 20 times, don't answer that one. No, not that one, not that one. It's always in one direction. She doesn't cut off anybody saying, I don't like Alec Baldwin. That's for sure. It's always in one direction. This is a homicide case. Prosecutors are required to do better than this. This indictment should be dismissed.
All right, and you may close, Ms. Morrissey.
I don't recall representing to this court that I reached out to Mr. Hall's attorney. I did not represent that to the court today. I specifically indicated that there was always a problem because he was represented by an attorney that was non-responsive. Mr. Souza isn't represented by a lawyer. I have no idea what Mr. Spiro is talking about. Everything that he's saying to you right now is a complete misrepresentation about what has happened. And that's what these people do. So hearsay is admissible in grand jury. Hancock and Rice, I never said that they couldn't testify about what people told them. I didn't want Hancock testifying about what people told her if it wasn't going to be responsive to the question. That is clear. I'm not going to have Hancock talk about gun safety on movie sets if all she knows is the wrong way to do it. Hearsay is admissible in grand jury. All of that was absolutely appropriate. Mr. Rice's testimony was perfectly appropriate. It was based on hearsay. This court knows very well that hearsay always comes in before the grand jury. But if I'm talking to a detective and I know that her answer is going to be based on unreliable hearsay, and that's what it was unreliable hearsay, then I'm going to stop it because I want the grand jury to get the most accurate responses to their questions. You know, Mr. Spiro wants to say to this court this morning that I'm just kind of making this up as I go along, that I had no intention of ever presenting anyone over video. I can give you the names of the DAs in the second that I spoke to prior to taking this case to grand jury to ensure that this was a practice that was normally done. And why am I speaking to DAs in the second?
She's going to say she's talking to the second because that's where they do all of these things, right?
Rather than DAs in the first, because DAs in the second deal with more complicated cases. They see more alert letters. So that's the reason that I was reaching out to them. I'm not going to sit here and be called a liar. I absolutely I did everything that I have told the court that I did today. He's right. I didn't reach out to Mr. Hall's attorney, and I didn't tell the court today that I did. So let's be clear. Mr. Spiro is intentionally trying to misrepresent and mislead this court right now. Thank you.
Ooh, that's a hell of an allegation. Is intentionally trying to mislead this court. That's an allegation of improper behavior. That is, that's an allegation of, unethical behavior. Ooh.
All right. Thank you, counsel, for your presentations. I am going to issue my ruling by order next week. I'll put it in writing. Okay.
Thank you, Your Honor.
You may look for that. Thank you very much. We are in recess.
All right, so that's exciting. That is that's exceptional. As I said, my read is 30% chance, but it should have been 0. It should have been 0%. And the fact that it's anything other than 0% is really, really bad for the prosecution on this one. I don't think it's going to get thrown out. I think that, that's unlikely. But it's not 0%. It's not. So we'll see. We'll see what ends up. Mattering on this one, because yeah. I don't know what to make of this right now. I don't know how to call this one quite yet, but we'll see. I hope it runs. I am planning, if I can, to be in New Mexico. That'll mess up my plans if this gets thrown out, but there is a chance. So yeah, that's the hearing. Not a whole lot of super chats to cover here before we go. Yellow Pill NP, the huge difference between this case and the ones cited is that she knows how the witnesses will testify because they just recently testified in a case with the same set of facts relevant to this one. I don't think the court's going to hang their hat on that, but it is a bit of a difference there. So, yeah. Candy Marie, thank you for the 10 gifted memberships. Much appreciated. All right. So Monday, we are going to have Monday. I see. Hey, if it gets thrown out, you could just divert to Massachusetts. Massachusetts probably won't let me in that courtroom. So I don't know that I'd make it in there for that. But Monday we're going to be going over what happened on Friday in the Karen Reed. I might look at Corey Richens as well. I haven't decided yet for certain. We will have to see on that one. So yeah, that's it for today. Have a good night, everybody, and I'm going to go try to get some sleep. So see you, folks. Where's my outro? It is not the pigeon business. Yeah, there we go.